Here.
May I have your lordship's gracious leave, my lord, to resume? My lord, I, over the weekend, prepared a written note so that I could keep my time limit. I've handed over, my lord, a copy of the submission. Lord, I'm now going to combine the points relating to Article 74, 163(1) and 200. That's the way in which, my lord, I'm progressing. It also deals with 361, so your lordships will appreciate how all answers are actually found in the various judgments of this court. That's my submission. My lord, the first part is India's constitution envisages a parliamentary democracy with a cabinet form of government. In India's democratic republic, ultimate sovereignty lies with the people. Parliamentary democracy, as adopted by the framers of our constitution, is the embodiment of the collective will expressed through the legislature. The executive emerges from the legislature and is accountable to it. The executive exists by virtue of the confidence of the elected house and is answerable to it. This constant chain of accountability ensures that governance is never severed from popular consent. The ultimate responsibility to make law lies with the parliament and the state legislatures. The executive government is responsible to parliament in the case of union and to the state legislature in the case of the states. The president and governor are therefore titular heads bound by the aid and advice of the Council of Ministers of the Union and the states as the case may be. This fundamental understanding of the Constitution of India is evident from several decisions of the Supreme Court. Now, my lord, I have actually lifted this from different paras in Shamsher Singh, and your lordships will find they will have a bearing on 200. That is why, my lord, I extracted specific sentences.
They will have bearing on?
My lord, on 200. What is the meaning of the word governor? And what is his function under 200? And what is the meaning of the word declare in 200? In Shamsher Singh, this court held that the president and the governors are constitutional heads of the union and the states, respectively. In order to be accountable to the will of the people, they must perform their functions on the aid and advice of their Council of Ministers. Speaking for the majority, Chief Justice Ray held, under the cabinet system of government as embodied in our Constitution, the president and the governors are constitutional or formal heads of the union, states who exercise their powers and functions on the aid and advice of their Council of Ministers. The powers of the president and the governor are similar to the powers of the Crown under the British parliamentary system. Responsibility for the Crown's actions is borne by advisors who have the confidence of the legislature, which in turn has the confidence of the people. Article 361 grants immunity to the president and the governor, preventing them from being sued for executive actions of the government. The reason is that neither the president nor the governor exercise executive functions individually or personally. While the executive power of a state may be vested in the governor, this power is actually carried out and exercised by ministers, elected members of the executive, under the rules of business made under Article 166(3). These rules are also formulated on ministerial advice. The view expressed in the state of UP versus Baburam Upadhyaya that the power of the governor to dismiss a public servant could not be delegated was no longer good law. Following the judgment in Motiram Dekar, it was clear that such a power could be delegated subject to the provisions of Article 311. This distinction made in Jayantilal Shodhan between executive functions of the union and functions of the president did not lead to the conclusion that the president enjoyed any discretionary power. Whether functions exercised by the president are functions of the union or functions of the president, they have equally to be exercised with the advice of the Council of Ministers. The same is true for the functions of the government. Wherever the Constitution requires the satisfaction of the President or the Governor for the exercise of any power, the satisfaction required is not the personal satisfaction of the President or the Governor. It is the satisfaction of the Council of Ministers on whose aid and advice the President and the Governor exercise their functions. Thus, the decision in Sardarilal versus Union, which held that the President had to be personally satisfied before acting under Clause C of the proviso to Article 311(2), did not lay down the law correctly. Unlike Article 74, Article 163 expressly recognized that the Governor could perform some of his functions in his discretion. Provisions that enable the Governor to act in his discretion relate to the Governor's special responsibilities in respect of Nagaland under 371A and his responsibilities under Para 9(2) of the 6th Schedule. Governors may also act in their discretion while making a report to the President under Clause 1 of Article 356 and while reserving bills covered by the second proviso to Article 200 for the President's consideration. The Governor is required to pursue such courses as are not detrimental to the state. The Constitution does not aim at providing a parallel administration within the state by allowing the Governor to go against the advice of the Council of Ministers. Justice Krishnaya authored a concurring opinion on behalf of himself and Justice Bhagwati. They held that the question before the court was whether, under the Constitution, the President and Governors were real repositories of power, or whether they played a role similar to the British Crown. The judges also expressed their surprise at the extreme views that had been advanced in support of a greater role for the President under the Constitution. My Lord, the Union of India has done this in this case. That is why, my Lord, I'm making this submission. The learned judges referred extensively to speeches in the Constituent Assembly that highlighted the establishment of a parliamentary system where power was exercised by ministers. In particular, they referred to a speech by Sir Alladi Krishnaswamy Iyer, who argued that a president who did not heed the advice of his ministers would be thwarting the will of Parliament for which he could be impeached. The argument that the President's oath of office may require him to act in his discretion was rejected. My Lord, I'm referring to this for the reason, if your lordships have seen the submissions of the Union carefully, there is a reference to an excerpt from Sirvai with reference to the oath of office administered to a president. That's why, my Lord, I'm reading this carefully. The argument that the President's oath of office may require him to act in his discretion was rejected. It was held that the President would not be defending the Constitution by denying the essence of cabinet responsibility. He would be subverting it that way. The expression aid and advise were terms of art. They meant that in a cabinet system, the aider acts and the advisor decides in his own authority and not subject to the power of the President to accept or reject such an action or decision. In respect of all the Governor's constitutional functions, it was the ministers who acted. It was only in the narrow area specifically marked out for discretionary exercise by the Constitution that the Governor was not bound by ministerial advice. Having discussed the functions of the Governor under the Constitution, including those under Article 200, the learned judges concluded that expanding the scope of the judgment in Sardarilal to enable the Governor to exercise discretion in respect of all his functions would make national elections a numerical exercise in expensive futility. A diarchy would be established with two parallel authorities exercising powers of governance. Now, my Lord, I come straight to the text of Article 74, both pre-amendment and post-amendment. In the Constitution as originally enacted, Article 74(1) stood as under, there shall be a Council of Ministers with the Prime Minister at the head to aid and advise the President in the exercise of his functions. This court in Shamsher Singh examined the role of the President in the context of Article 74(1) as reproduced above. The court's judgment was delivered on 23rd August 1974. Subsequently, Clause 1 of Article 74 was amended by the Constitution 42nd Amendment Act 76. Following the amendment, which came into force on January 3, 1977, Article 74(1) provided, there shall be a Council of Ministers with the Prime Minister at the head to aid and advise the President, who shall, in the exercise of his functions, act in accordance with such advice. The amendment thus made it obligatory for the President to follow the advice of his ministers. By doing so, it endorsed the judgment of this court in Shamsher Singh. In this regard, the observations of this court in S.P. Gupta may be borne in mind. It is clear that the President is a constitutional head and is bound to act on the aid and advice of the Council of Ministers. This was the position even before the amendment of Clause 1 of Article 74 by the Constitution 42nd Amendment Act, but the position has been made absolutely explicit by the amendment. What was judicially interpreted even under the unamended Article 74(1) has now been given parliamentary recognition by this constitutional amendment. Article 74(1) was amended further by the Constitution 44th Amendment Act 1978, which came into force on 20th June 1979. A proviso was inserted to the provision to enable the President to require the Council of Ministers to reconsider its advice once. Article 74(1) and the proviso, I read the proviso, provided that the President may require the Council of Ministers to reconsider such advice, either generally or otherwise, and the President shall act in accordance with the advice tendered after such reconsideration. Now, my lord, I deal with this MP Special Police Establishment case. The case of MP Special Police Establishment was dealing with the question of whether previous sanction required under Section 197 of the CRPC for prosecuting ministers under Sections 13(1)(d) and 13(2) of the Prevention of Corruption Act 1988, read with Section 120(b) of the IPC, would be accorded by the Governor on the binding aid and advice of the Council of Ministers. The case did not involve the Governor's functions under the Constitution. The exercise of his discretion was not governed by Article 163(1) of the Constitution. As such, the observations of the court were limited to the facts and circumstances of that case, and the observations made in the context of Article 163 ought to be interpreted in its proper context. It is also important to note that at para 12 in the MP Special Police Establishment, this court inadvertently referred to para 154 of Shamsher Singh as declaring the law laid down in that case. It is important to clarify that the said paragraph forms a part of Justice Krishna Iyer's concurring opinion. The majority judgment in Shamsher Singh is in paras 1 to 90 of the report, Ray CJ, writing on behalf of himself and Justices Palekar, Matthew, Chandrachud, and Alagiri Swami. This inadvertently quoted para 154 of Shamsher Singh led to the observation in MP Madhya Pradesh Police Special Establishment that discretion may be available to governors where situations bring about peril to democracy. Such a conclusion is not supported by the majority opinion in Shamsher Singh. In fact, it is respectfully submitted that any unfettered discretion conferred upon a governor can severely endanger our democratic republic. I then come along to the next judgment, which is Dr. Chauhan's judgment in Justice R.A. Mehta's case, State of Gujarat versus R.A. Mehta. It is submitted that the judgment of this court in R.A. Mehta has correctly laid down that governors must act in the aid and advice of the Council of Ministers, save in a few well-known exceptional situations. This court also correctly identified the functions governors perform on the aid and advice of their Council of Ministers. Notably, these functions included giving assent to bills or withholding assent under Article 200. The court held, however, the power to grant pardon or to remit sentence, the power to make appointments, including that of the Chief Minister, the Advocate General, the district judges, the members of the Public Service Commission, are in the category where the governor is bound to act in the aid and advice of the Council of Ministers. Likewise, the power to prorogue either House of Legislature or to dissolve the Legislative Assembly, the right to address or send messages to the houses of the legislature, the power to assent to bills or withhold such assent, the power to make recommendations for demands of grants, and the duty to cause to be laid for every year the annual budget, the power to promulgate ordinances during the recess of the legislature, also belong to this species of power. Again, the obligation to make available to the Election Commission requisite staff for discharging functions conferred upon it by Article 324(1) and Article 324(6), the power to nominate a member of the Anglo-Indian community to the Assembly in certain situations, the power to authorize the use of Hindi in proceedings in the High Court, are illustrative of the functions of the governor qua the governor, which means, my lord, on aid and advice. Now, my lord, we come to these words in 163(1), by or under the Constitution, because by must mean something, under must mean something else. Now, my lord, please see para 18. Under Article 163(1) of the Constitution, governors are to exercise their functions on ministerial advice, except insofar as they are, by or under this Constitution, required to exercise their functions in their discretion. It is respectfully submitted that the Constituent Assembly's decision to retain insofar he is, by or under this Constitution, required to exercise his functions or any of them in his discretion, in Article 163 was meant to serve as a safeguard, ensuring that the governor's discretion is confined only to situations explicitly specified in the Constitution. Dr. Ambedkar clarified that it was not a general clause giving the governor power to disregard the advice of his ministers in any matter in which he finds he ought to disregard. Similarly, in the debates regarding the mode of appointment of a governor under Article 155, Dr. Ambedkar remarked that any method of appointment did not change the purely ornamental role of the governor, since he was bound to act and aid and advise of the Council of Ministers in all matters under the Constitution. In sharp contrast with this understanding of Dr. Ambedkar, it has been contended by the Union that the Constituent Assembly debates indicate that the governor was, by virtue of holding the highest constitutional office in the state, empowered to exercise his discretion independent of the aid and advice of the Council of Ministers. It is submitted that the governor is empowered to act in his discretion by the Constitution, where a provision of the Constitution expressly enables him to do so. The expression under this Constitution refers to specific provisions of the Constitution that empower the President to enable the governor to act. So, my lord, like a 356(1) proclamation, then the President directs the governor to act as his delegate. It's in respect of this. A governor, now, my lord, by the Constitution, I have set out all the relevant articles. Under the Constitution is Article 356(1)(c), 371, and 371(c). Well, 356(1)(c) is when a state is placed under President's rule, the President allocates under ancillary and consequential provisions, well, 356(1)(c), specific powers to the governor to act as delegate. Likewise, my lord, in respect of Maharashtra and Gujarat in certain specific areas like Kolhapur or Kutch, my lord, Article 371 says President by order can direct the governor. Similarly, my lord, Article 371(c). So in those cases, it becomes under the Constitution. In the other cases, it is by the Constitution. Now, para 22, my lord. A governor may also be required to perform functions under a statute. In such cases, the source of the governor's powers is the statutory provision itself and not Article 163(1) of the Constitution. Where the Constitution contemplates discharge of functions under a statute, It does so expressly. For example, Article 76(2) requires the Attorney General to discharge functions conferred by or under this Constitution or any other law. Exercising discretion under a statute is consistent with the oath of a governor under Article 159, which obligates him to not only defend the Constitution, but also the law. Illustrative examples of statutory functions include the grant of sanction to prosecute a public servant under the now repealed Section 197 of the Code of Criminal Procedure, or the exercise of statutory functions by the governor in his capacity as chancellor of a university, or the exercise of statutory functions by the governor in his capacity as the ex officio chairman of a shrine board. In view of the above, the suggestion at para 49 of the judgment in Justice Mehta that the words under the Constitution also cover functions that governors perform under statutes may not be correct. Well, I thought I should clarify where it lays down the law consistently that one sentence, my lord, may not be correct because they are statutes of the legislature.
According to you, under 197 of CRPC, it's the governor's discretion.
Well, under 197, it's a statutory because it's
statutory, but then whether there also
it is in his discretion.
There,
Because
he's not required to act on the aid and advice of the.
No, not on 197, not for sanction. Well, this is held in two judgments, not only MP establishment. Before this, we had Ramdas Naik versus Antule. There also, my lord, your lordship said he acts independently of the aid and advice of the Council of Ministers. But that's a statutory function. My lord, Mata Vaishnav Devi Shrine Board, your lordship said, if he is mentioned, he acts independently. He does not take aid and advice. He is a chancellor of a university. Please.
Has any judgment considered the scope of sub-article 2 of 163?
My lord, on 163(2), I must tell you, lordships, there are two judgments. I'm glad your lordships asked me. I thought I must straight away answer it. 166(3)(2), my lord, Justice Variava has placed a lot of emphasis on 163(2). But, my lord, there is another opinion, which is in the Nebbia case, where they say 163(2) is not the investment or investiture of power or discretion. It's only 163(1). Justice Variava thinks it's 163(2).
Well,
that's all, man. These are the two.
but the reason why I'm asking you is
Please,
that,
certainly.
if we take that line that the powers are only those which are crystallized in the Constitution, identified in specific provisions of the Constitution, then in which case empowering or declaring, rather, it's not an empowering, it's a declaration in sub-article 2, which says that that discretion is finalized. So therefore, there is the scope for, the Constitution recognizes the scope for the governor to come to a conclusion that this is in his discretion, and that decision making is given a finality. That's the purpose of sub-article 2, which means that the process of identification is not so much crystallized in specified articles, but there is a process by which he would identify, and his identification is declared to be final.
My lord, that I respectfully urge your lordships to take a contrary view, because, my lord, that would mean in all places where he acts on aid and advice, he may then claim discretion. This is the danger. My lord, I'm making your lordships alive to the possible outcome of this interpretation under 163(2). If it was a standalone provision, my lord, it might be different. But it is in the context of 163(1). That is why the words are by or under the Constitution. And, my lord, this is what Nebbia correctly interprets, that 163(1) alone is relevant. 163(2) does not give a source of power.
We just blank.
Now, my Lord, please come to para 24. That the expression under this Constitution does not extend to legislation is also clear from an examination of other provisions of the Constitution. For example, Article 165(2) refers to functions conferred on the Advocate General for a state by or under this Constitution or any other law for the time being in force. Similarly, Article 173(c), which deals with qualifications for membership to the state legislature, speaks of qualifications prescribed by or under any law made by Parliament. The words under this Constitution cannot therefore extend to other laws, including statutes. This is the. It is submitted that the judgment in Nabam Rebia has correctly laid down that the governor cannot be seen to have such powers and functions as would assign to him a dominating position over the state executive and the state legislature. This court, my Lord, may I take your lordships to that para if it's needed, because that answers my Lord, the Honorable Justice Narasimha's question. My Lord, please take volume Roman 5, 22. My Lord, it would be yeah, thank you. Please go, my Lord, to volume 5, V22. Just one para, my Lord, in the judgment. My Lord, at page 8618, printed page 8618, para 148.
Para 148.
Yes.
We already marked that.
Yes. My Lord, this is with reference to my Lord Justice Narasimha's question. The above, sorry. The above position leaves no room for any doubt that the governor cannot be seen to have such powers and functions as would assign to him a dominating position over the state executive and the state legislature. The interpretation placed in Article 163(2) on behalf of the respondents has just that effect, because the following contentions advanced on behalf of the respondents. Firstly, whenever a question arises, whether in discharging a particular function, the governor can or cannot act in his own discretion, according to the respondents, the discretion of the governor on the above question is final. Secondly, since the provision itself postulates that the decision of the governor in his discretion shall be final, and the validity of anything done by the governor shall not be called in question on the ground that he ought or ought not to have acted in his discretion, according to the respondents, makes the governor's orders based on his own discretion immune from judicial review. Accepting the above position will convert the governor into an all-pervading super-constitutional authority. This position is not acceptable because on examination of the executive and legislative functions of the governor from the surrounding provisions of the Constitution clearly brings up that the governor has not been assigned any significant role either in the executive or the legislative functioning of the state. The position adopted on behalf of the appellants, on the other hand, augurs well in an overall harmonious construction of the provisions of the Constitution. Even on a cursory examination of the relevant provisions of the Constitution, we are inclined to accept the contention advanced on behalf of the appellants.
Just a second. Let me check 114.
My Lord, I'm grateful to my learned friend. My Lord, at para 149, if your Lordship sees at the
Go
bottom,
to the constitutional debates.
yes, the Constituent Assembly debates, your Lordship have seen it. Now, my Lord, let me return to my note. Please come to para 27. Para 27, my Lord. Additionally, governors are also empowered to act in their discretion where such intent emerges from a legitimate interpretation of the provision concerned, and the same cannot be construed otherwise. It is submitted that the governor's power to act in his discretion under 356(1) and the second proviso to Article 200 would fall under this category. But I've already referred to para 147. Now, please come to 29. Keeping in mind the emphasis of the court in Nabham on the very limited role of the governor, this court's endorsement of the report of Justice Punchi Commission was only to the extent that it cautioned against the grant of wide discretionary powers to the governor at the expense of the real executive, namely the Council of Ministers. Now, my Lord, I have taken the submissions so that your Lordship see, and my Lord, I say so with great respect to the learned Solicitor General. My Lord, he argued this case with extraordinary industry. I say so with great respect. It is respectfully submitted that there is a divergence between the submissions made by the learned Solicitor General on behalf of the Union and the law as laid down by this court. This divergence is being pointed out to assist this court and not based on any instructions. In respect of the role of the President, the written submissions of the learned Solicitor General contend, relying selectively on the writings of H.M. Sirbai, it is suggested that the President of India may in certain circumstances in his discretion dismiss the Prime Minister and the Union Council of Ministers or dissolve the Lok Sabha. It was contended that these powers also extend to the governors. That the President may in his own wisdom determine whether to assent to a bill reserved by the governor for his consideration. That the President may act in his discretion in making a reference to this court under Article 143. It is stated that the President, if he so wishes, can always in his discretion further refer the matter to the Supreme Court for its own opinion. That the President and the governors ensure that both the central and state governments operate within the parameters set by the Constitution, balancing autonomy with oversight. My Lord, there is, with respect, my Lord, it is not correct. The President and Governor, my Lord, do not have oversight over the Honorable Prime Minister or the Chief Minister. I thought, my Lord, it must be clearly stated. These submissions are not, my Lord, correct. It is respectfully submitted that submissions advanced on behalf of the Union in respect of the powers of the President do not accurately reflect the law as laid down by this court in Shamsher Singh. They are also contrary to the express words of Article 74(1) of the Constitution. It is submitted that the President of India, who is a constitutional or formal head of the Union, must perform his functions on the advice of his Council of Ministers, while the proviso to Article 74(1) enables the President to require the Council to reconsider its advice once he is obligated to act in accordance with the advice tendered after such reconsideration. The President is not empowered to act in his discretion while making a reference to this Honorable Court under Article 143. In any case, there is absolutely no question of the President in his discretion dismissing the Prime Minister, other ministers, or dissolving the Lok Sabha. Any such construction.
That is not his argument. He says that
No, my Lord, I have gone by his written submissions.
Yes.
I want your Lordship.
So, insofar as
President
President
is bound by the aid and advice.
insofar as President is
My Lord, I only went through his.
the learned solicitor distinguishes President and Governor. According to him, the President is bound by the aid and advice of the cabinet,
My Lord,
not the Governor.
My Lord, I have taken an effort to read the submissions. Whichever portions are not consistent, I'm just pointing it out And my Lord, I'm doing it with a great deal of deference, respect, and admiration for the learned Solicitor General. But my Lord, it's my duty just point out so that it's accurate. That's all. My Lord, if you think there is an error in his submission, you must attribute it to me. I'm senior to him. You must attribute it to me. I must be the one to take it on my shoulders. My Lord, these are some privileges. I hope the Solicitor General doesn't take.
No.
My Lord, please come to para 35. As
You are not as friendly to him as Dr. Singhvi and Dr. Mr. Kapil Sibal.
I don't know who's more honest. I don't know who's more honest.
We can't answer that.
As far as the role of the governor is concerned, the union has submitted that the governor acts as a representative of the president and exercises executive powers of the state on behalf of the president. However, it is also submitted that the governor discharges his duties as a statesman, unaffected by the political composition at the center or in the state concerned. That the governor is the agent of the center who will guard the center's policy. This contention is based on a speech in the Constituent Assembly. That the governor's power to summon and prorogue the state legislature is a legislative power. It is suggested that these powers can be exercised by the governor in his discretion. It is submitted that the governor does not act as a representative of the president or an agent of the center. The governor swears an oath under Article 159 to devote himself to the service and well-being of the people of his state. This commitment clearly indicates that the governor is intended to act in the interests of the state. Insofar as the union's policy is concerned, the same is adequately protected under Article 256 and Article 257(1). Additionally, in respect of the state's power to make laws under List 2, the states enjoy executive and legislative power conferred under the Constitution. The wide range of discretionary powers that are identified in respect of the governor are contrary to the judgments in Samsher Singh and Nab. Lastly, it may be noted that the union's submissions have the effect of resurrecting this court's judgment in Sardar Lal, which was unanimously overruled in Samsher Singh. The Union of India has highlighted the functions governors perform under Articles 154, 163 to 167, 165, 233, 234, 243K, 316. Well, I've referred to all of them. These are referred in the written submissions. In the context of these provisions, it has been argued that while these functions may sometimes be formal and facilitative and rooted in aid and advice, some discretion is key to protect constitutional governance, federal balance, vulnerable regions and groups, and the continuity of the state. Well, this is what I'm saying is not accurate. In other words, it is contended without foundation that governors may possess discretion in appointing the Advocate General, summoning the state legislature, addressing the houses, making a special address to that legislature, assenting to bills, making decisions concerning the disqualification of members, the laying of the annual budget, and appointing district judges, appointing members of the state public service commissions, granting pardons, and promulgating ordinances. The union also argues that the governor has enough discretion to effectively veto a bill by simply withholding a bill without returning the bill to the House for reconsideration under Article 200. Based on the law laid down in Samsher Singh, it is respectfully submitted that this argument of the union in support of an absolute power to veto will render the state elections completely futile. These submissions are contrary to the letter and spirit of the Constitution. Now, my Lord, I come to 200. The Constituent Assembly debates firmly demonstrate that the founders intended the governor to only be a titular head acting on ministerial advice. Article 200 was derived from Section 75 of the Government of India Act 1935. However, unlike Section 75, which gave the governor express discretion to assent, withhold, or reserve a bill, the expression in his discretion was deliberately omitted from Article 200. Dr. Ambedkar, in the Constituent Assembly debates on 31st May 1949, had clarified that the role of the governor was purely ornamental. My Lord, I must say, with respect, I truly admire the industry of the learned Solicitor General. He put Government of India Act 1919, then he put 35, then he put the Rao Committee, the drafting committee. But my Lord, this is a new constitution. It is a break from the Government of India Act 35. So the discretion which is enjoyed under the 1919 Act or the 1935 Act must not actually creep into the interpretation of the Constitution. Then, my Lord, para 45. The governor is not conferred with any discretion by or under the Constitution in relation to Article 200. Under Article 200, the governor is bound to act in accordance with ministerial advice while deciding whether to A, grant assent, or B, withhold assent for the purpose of returning a bill to the House or Houses for reconsideration, or reserve a bill for the President's consideration. The sole exception is found in the second proviso to Article 200, which entitles the governor to exercise discretion in reserving any bill for the President's consideration if, in the opinion of the governor, the bill would derogate from the powers of the High Court as to endanger its constitutional position. Now, my Lord, the next point is whether this power to assent is a legislative power. Assent by the governor under Article 200 is not a legislative power. The governor is a part of the state legislature under Article 168. However, the assent of the governor under Article 200 is not a legislative power. The act of assent is also quintessentially an exercise of executive powers of the state, which could have characteristics of a legislative act. My Lord, he is the head of the executive, so he also acts as the head to declare a bill to be a law. My Lord, that declaration in Article 200 is to declare. My Lord, what do we mean by law declared by the court? A bill is declared to be a law by the assent of the governor. Chapter 4 of the Constitution specifically provides for the legislative power of the governor. The sole provision under this chapter is Article 213 relating to the power to promulgate an ordinance. Pertinently, even the legislative power to promulgate ordinances is exercised on the aid and advice of the Council of Ministers. The 7-judge bench in Samshay Singh clarified that all other powers of the governor are executive powers, even if they partake of legislative or judicial actions. Articles 200, 201 fall under the subheading of legislative procedure under Chapter 3. A bill needs to be approved by all components of the state legislature to have the force of law. Since all executive power of the state is vested in the governor, under Article 154, the governor's assent represents his imprimatur and certification on aid and advice in relation to a bill passed by the legislature. Even though governors are a part of the legislature, Article 158(1) expressly precludes them from being a member of the House. They are not entitled to participate in the proceedings and affairs of the House. They do not have a right to vote or participate in deliberations. The right of the governor to address and send messages to the House under Articles 175 and 176 are exercised only on the aid and advice of the Council of Ministers. Similarly, the governor's powers under Article 202(1) and 207(1) are also exercised on ministerial advice. This unique relationship between the governor and the legislature has been explained in Valluri Basavaya and State of Bihar. versus Kameshwar Singh. Thus, while the governor's assent under Article 200 forms a part of the legislative procedure, it does not constitute legislative power that may be exercised independent of ministerial advice. It is therefore most respectfully submitted that the submission of the Union that Article 200 confers a legislative power upon the governor is liable to be rejected. The text of Article 200 makes it evident that the governor must follow one of three courses of action. It is no longer res integra that a governor must exercise one of only three courses of action under Article 200 under the aid and advice of the Council of Ministers: grant assent or withhold assent for the purpose of returning a bill to the House as soon as possible for reconsideration, and if the bill is passed again by the House, the governor must grant assent or reserve a bill for the President's consideration. This Honourable Court has, on at least 5 separate occasions, held that the substantive part of Article 200 mandates that the governor shall exercise one of only 3 specified courses of action. In case of withholding of assent, the governor is bound to follow the procedure prescribed under the first proviso and assent to the bill if it is ultimately presented to him after reconsideration by the legislature. My Lord, there was some emphasis on the words that the governor shall declare. But my Lord, that declaration does not have an independent meaning in that article. Declare means you do one of these 3. It is a form of action. The word declare, my Lord, is a form of action. One of the 3. Assent the bill, that's also a declaration. Return it to the House for reconsideration, also a declaration. Reserve it for consideration of the President, also a declaration. So there are no 2 separate acts in 200.
It only excludes
Pardon?
the pocket veto.
Yes.
It excludes the pocket veto.
That's
because there's no declaration.
That's right.
You just put it in your pocket and sleep.
That's right. In any case, the only 3 courses of action under 200 are based on the binding aid and advice of the Council of Ministers. My Lord, I must, in fairness, point out that, my Lord, even though Chief Justice Ray took the view that the second proviso to Article 200 conferred a discretion on the governor, Justice A.P. Sen in Balluri Basavaya Chowdhury said even in that second proviso, it's on ministerial aid and advice. My Lord, it might look at first blush to any reader that there's a little inconsistency in both those 2 judgments. But my Lord, there's a way to harmonize both. Namely, it is possible that a cabinet may also say that this does touch upon the jurisdiction of a high court. Please send it to the President, which is why Justice Sen said it could be also on aid and advice. But, my Lord, the view taken by Chief Justice Ray that this is a duty on the governor, it's because of the word shall not assent. My Lord, he drew inspiration from the words shall not assent. So there's an obligation on the governor not to assent in respect of a bill which encroaches upon the jurisdiction of the High Court. Now, my Lord, we come to withholding of assent. The Union submits the governor has unqualified discretion to effectively veto bills by withholding assent simpliciter. My Lord, veto is a well-known expression, my Lord. It's not necessarily a pejorative per se. It is an expression. It is contended that the first proviso provides an independent 4th course of action to the governor. This stance is not only contrary to law, but also erroneous based on a plain reading of the proviso. Any interpretation that confers upon the governor an unqualified power to veto is antithetical to the existence of elected state legislatures under the Constitution. A governor is only entitled to withhold assent on ministerial advice for the purpose of returning a bill to the House as soon as possible for reconsideration, and if the bill is passed again by the House, the governor must grant assent. Further, the first proviso requires the governor to return a bill for reconsideration as soon as possible after the presentation to him of the bill for assent, as soon as possible, imposes a constitutional obligation of urgency, immediacy, and expedition, so that a bill is not held up for want of assent. The constitutional mandate to act as soon as possible necessarily implies the mandatory character of the action. Granting the governor any discretion would render this constitutional expression meaningless. The nexus between withholding of assent and the first proviso is further evident from the expression, the governor shall not withhold assent therefrom at the end of the first proviso. The first proviso begins with an urgent mandate to the governor to return a bill to the House for reconsideration in case assent was withheld in the first instance. Thereafter, the House is expected to deliberate and decide whether the bill should be passed again. And finally, in case the bill is passed again, the governor is mandated to not withhold assent. This implies that the initial withholding of assent is conditional and tethered to the duty of the governor to necessarily return a bill for reconsideration as soon as possible, followed by the duty of the House to reconsider and pass the bill if it so wishes, and the duty of the governor to necessarily assent if the bill is passed again. The Union of India has relied on the word may. Please, Manoj, for a moment, look at that. The Union of India has relied on the word may in the first proviso to contend that it is not mandatory to take recourse to the first proviso in case of withholding of assent. It is submitted that the use of the word may denotes that the first proviso shall be applicable only when assent is withheld by the governor. The use of the expression may was necessary, keeping in mind that the governor must exercise one of the three actions when a bill is presented for assent. That's why, my lord, the word may, because he can do one or the other. Therefore, may. This understanding has been rightly affirmed in state of Punjab and state of Tamil Nadu. The union has also contended that the governor has an independent option to reserve a bill for the president's consideration after it is repassed by the legislature pursuant to the first proviso. However, this contention is unsustainable, as the five-judge bench in Valluri Basavaya held that the governor was bound to give his assent when the bill is reconsidered and passed by the assembly. My lord, there's no question of sending it to the president after that. So, my lord, this is held in these two decisions. Even otherwise, the expression shall not withhold assent necessarily means that the governor must assent. By contrast, Section 24 of the Government of NCT of Delhi Act expressly allows the Lieutenant Governor to declare either that he assents to the bill or that he reserves the bill for the consideration of the President. My lord, in Para 62, I have pointed out which are the provisions where the bills have to be reserved on ministerial advice by the Governor for President's consideration. I've listed out, my lord, all those articles in Para 62. My lord, these are the articles in the Constitution.
Again, according to that, is to be only on the aid and advice of the cabinet.
Only on the aid of it.
Not in his own discretion.
Yes, there's no discretion, my lord. So he has to, this is the way, my lord. In fact, my lord, rules of business are incidental, may I say, transaction rules of business. But your lordships will find both the union government and the various state governments in their transaction of business rules under 166.3, 77.3, all have provisions, my lord, of how bills, who processes the case when it has to be reserved for the president or for the governor. They have, my lord, specific rules, but they are rules of business. I'm going by the constitutional provisions. My lord, please see. So, my lord, this is on ministerial advice. Now, please come to bill falling through. My lord, this bill falling through was an important part of the argument. My lord, bill falls through means, my lord, it is not passed again by the House. It falls through. It falls on the floor of the House. Well, Lord, if one were to use that expression, something falling through, it goes straight to the floor. That is what that expression falls through means. That if you don't act in accordance with the first proviso and bring it back to the governor for assent, it's gone. It's just fallen through. It has failed. Now, my Lord, the judgments in Kameshwar and Valluri Basavaya Hext conclude that the governor may withhold assent, in which case the bill falls through unless the procedure indicated in the proviso is followed. As has been rightly held in Tamil Nadu, the words bill falls through do not suggest that the governor may simply withhold his assent to a bill. A bill would only fall through if the legislature, upon a remit for reconsideration, chooses not to pass the bill. Then, my Lord, we come to timelines. I now come straight away to timelines. At the outset, it is submitted that questions 5 and 7 of the present reference are premised on a factual statement that Article 200 does not stipulate any time frame upon the governor for the exercise of constitutional options under 200. It is respectfully submitted that the question fails to appreciate that the expression as soon as possible in Article 200 is a term of art and that imports a sense of immediacy mandated by the Constitution. The expression as soon as possible informs the exercise of all three courses of action under Article 200. This understanding has been recognized in these three judgments. It is submitted that the prescription of timelines is necessary to enable access to courts and judicial review. My Lord, the timelines in the judgment were for coming to the court. They were not, my Lord, timelines imposed on a governor or the president. They were only guidelines to regulate when would judicial review become available. It is submitted that the prescription of timelines is necessary to enable access to courts and judicial review. In Tamil Nadu, the prescription of timeline was considered essential for the exercise of judicial review, since it provided a set of definitive standards against which courts can embark upon their scrutiny. It therefore serves as a guideline for the courts to exercise restraint and wait for the prescribed period before entertaining a challenge to the inaction of the president or the governor. It is also important to distinguish between prescribing a timeline for the purpose of judicial review and prescribing a timeline for the purpose of deemed assent. My Lord, the judgment in Tamil Nadu does not talk about if you go beyond the timeline, there's deemed assent, not at all. For instance, in the United States and Singapore, the expiry of prescribed timelines automatically leads to deemed assent. By contrast, the expiration of timelines prescribed by Tamil Nadu does not lead to automatic deemed assent. It merely enables courts to review instances of inordinate delay. That's, my Lord, the only way, that's the limited way in which it has to be read. It is further pertinent to highlight that the timelines in respect of Article 201 were adopted from timelines prescribed by the Ministry of Home Affairs in their office memoranda. So, my Lord, they did not come artificially. They took, my Lord, they saw the office memoranda. It is submitted that the phrase as soon as possible imports a sense of immediacy mandated by the Constitution. However, if this is found to be ambiguous, the expression may also be construed to mean forthwith. This understanding is confirmed in the deliberations of the Constituent Assembly. The words as soon as possible were understood to place a strict obligation on the President to act with a sense of immediacy. My Lord, Purushothaman Nambudri is in a different case. It was on the existence of a legislature. Your Lordships can peruse it at convenience. I now come, my Lord, to justiciability. Para 73. It is submitted that judicial review and justiciability are two sides of the same coin The distinction is one of procedural nomenclature. Justiciability concerns the discovery of manageable standards, while judicial review is the process by which these standards are applied and enforced. Together, they ensure that all constitutional authorities, including the President and the governors, act within the limits imposed by the Constitution. In Bommai versus Union of India, my lord, I must mention that although Justice Jeevan Reddy's judgment refers to a, my lord, your lordships mentioned it to my learned friend, the Solicitor General. There are many passages in that judgment which suggest some sort of even in a quasi-federal setup, there is a strong centrist bias or unitarian sort of bias. But, my lord, the learned judge, has carefully said even then, for the purpose of governors' actions and the state legislatures to function untrammeled by powers of oversight, it is necessary that they must have independence and judicial review must exist. But my lord, when your lordships mentioned that to my learned friend, the solicitor, I immediately recollected those passages. Then, my lord, please see, in Bommai, this court held that when powers are entrusted to a constitutional authority for achieving a particular, Well, one of the advantages of sitting here is also noting down the observations and then reflecting over them. Because many times, my lord, in the process of any submission, one takes note of all the observations of learned judges. They actually form the cue. They form very useful cues to understand what is actually engaging the attention of the court.
Advantage would not have been available to you if you were somewhere else.
I agree with that.
Because on screen it is not that.
Often because of the space constraint, we fall on the screen.
But not as minutely as one sitting here.
It's true.
And then, my lord, please see,
Mr.
in
Datta is not aware of the context.
I know.
in Bommai, this honorable court further held that the amenability of the power under 356(1) to judicial review is beyond dispute, as the court is entitled to examine whether the condition has been satisfied or not. It is respectfully submitted that the union has placed reliance on the minority judgments in the said decision. My lord, both Justices Ahmede and Ramaswamy, they were the minority. My lord, when the Solicitor General finished his submissions, I followed a tradition in this court. My lord, we always walk across to the place where the lawyer has finished and congratulate him. My lord, I observed it in this case because there was so much of industry. And I must say, my lord, while I disagree with the submissions, but my lord, I marvel at his industry and perseverance. Further, like all other authorities, the president and the governors are bound by constitutional limitations. This court has consistently held that no exercise of constitutional power is immune from judicial review. My lord, this is Madhuram, BP Singhal, then my lord Perarivalan, then my lord State of Rajasthan versus Union of India, and State versus Tamil Nadu. Then my lord 163(2), my lord, is not a bar to judicial review. My lord, the next few paras, they deal with this. But para 83, my lord, is important because it was in SP Gupta that the judges said that 74(2) still does not prevent us examining the material and the reasons in support of a decision. So, my lord, the bar of scrutiny from the court under 163(2) is limited. Now, please see then, my lord, next one is Article 361. My lord, I have also dealt with it. I then come to deemed assent. My lord, that's para 86. It is respectfully submitted that in the state of Tamil Nadu, this honorable court, in exercise of its powers under 142, invoked the principle of deemed assent in respect of 10 bills which had been kept pending before the governor. The declaration was made having regard to the peculiar factual matrix of the case and to secure compliance with the constitutional mandate while maintaining the institutional dignity of the governor's office. This honorable court, after reviewing the events that had unfolded, concluded that the governor's conduct was lacking in bona fides and marked by repeated failures on the part of the governor to show deference to binding directions of this honorable court. That this court held in the circumstances of the case, it would be difficult to repose trust and remand the matter to him with the direction to dispose of the bills in accordance with the law laid down in the judgment. It is submitted that in the facts of the case in Tamil Nadu, this court's actions were warranted and are indeed commendable. They maintain the dignity of the office of the governor by preventing a situation where actions of a governor may have been subject to judicial comment. These directions also maintain the dignity of the office of the governor. Now, my lord, I come to the next portion. I'll sum it up, my lord, in a few words. My lord, the only decision which has taken a view that in a presidential reference, one can overrule the law is in the 2G case. That's the only judgment. It relies upon, my lord, a passage of Chief Justice Chandrachud in Re Special Courts bill. That passage, my lord, was in a different context. The question was whether the opinion rendered by the Supreme Court is binding on all the high courts in the country and the Supreme Court. It said, yes, perhaps we cannot bind ourselves, but it will definitely be binding on the high courts. In fact, my lord, the para which is accepted by Justice Jain, and I say with humility and respect, actually does not read the entire para in Special Courts Bill, because the last portion of that para is where Justice Chandrachud says, we are not unmindful of what a learned author, Etin Sirbai, said in his book, that these only have high persuasive value, but do not bind because they are not emanations of 141. It was in that context, my lord. So, my lord, I submit with respect, it is not a correct position to assume that a judgment can be overruled in a presidential reference. It has to be done, my lord, through normal adjudicatory process. My lord, there was one point which the learned Chief Justice asked us on the first day. It was a very important question. What happened to Article 1? Sorry. Your Lordships asked, what happened to Article 145.3? My lord, if your Lordship sees Article 145, well, except for Article 143, all the other articles from 123 onwards, right up to Article 145, they all deal with the powers of the Supreme Court. All the powers of the Supreme Court are adjudicatory except for 143. My lord, Supreme Court has complete powers. And my lord, those powers have to be read with 32. 32 itself, my lord, can be writs for any purpose. So 32 plus 142 plus 141 plus 144 plus 139. My lord, there's a provision in our constitution where your lordships have what are called ancillary powers. Your lordships would have seen those provisions. So it's a unique institution endowed and blessed with enormous power to be able to adumbrate on law and also, my lord, ensure that complete justice was done having regard to the facts of a particular case. My lord, there is an appendix to my written submissions, which your lordships will find. It lists out all the provisions of the Constitution where, my lord, the governor functions only on aid and advice of the Council of Ministers. My lord, I am extremely grateful. It's at page 1280.
Yes, yes, in that. Yeah.
My lord, I'm extremely grateful.
Why isn't there the second appendix where those provisions are?
There's only one appendix, my lord. Sorry.
Saying those which are identified by the constitution.
Yes, yes. Well,
And
the
if you
others
had a
I have
second
identified
appendix.
in the note. I can put it in an appendix also for the sake of comfort. Well, some debts of acknowledgement are due. I must do it. First is, my lord, debt of acknowledgement to the court for having given a most wonderful opportunity of hearing, consideration, and reflection. It has been, my lord, a distinct honor and a great privilege, a deeply personal felt privilege. The second, my lord, I want to thank my senior, Mr. Venugopal. My lord, he's senior to me at the bar. He is the senior most at the moment, my lord, amongst us.
He is the senior most.
I beg your lordship.
He is the senior most.
He is the senior most. And my lord, it was his magnanimity and very kind permission that I could precede him. I acknowledge my gratitude. I acknowledge my gratitude to Mr. Kapil Sibal, who ensured that I could assist your lordships. And my lord, my wonderful juniors and colleagues who were, my lord, repeatedly urged to make the written submissions as accurate and as true to form. And my lord, to my learned friend, the Attorney General and the learned Solicitor General, for their courtesy and dignity. My lord, I'm here to answer any questions your lordships may have asked.
It's been a pleasure hearing you because though we have been hearing all others here, for the first time that we are hearing you at such a length.
Only say, don't go back.
In last 6.5 years.
Stay.
For the good.
For the good.
It's good for the institution.
There's nothing better than this place.
I agree.
You would have realized now.
Yes, my lord.
I was in fact mentioning to Shraddhan that Mr. Subramanian is one of very few who retains the old graces of the bar. The fact that he deferred and allowed Mr. Sharma to address your lordships in the midst of his arguments when he was in full flow, it's not easy. The fact that he did that showed great.
No, and apart from that, sitting every day from
Every
10:30 to 4,
From beginning to end, I think it's a great
he
example.
is the only person
Yes,
who has glued to his seat from 10:30 to 4.
great example to everybody at the bar.
But my lord,
And the way he acknowledges everybody else.
But, my lord, I must also tell you, since two of your lordships are from Nagpur, my lord, I had the great privilege of getting from the Nagpur Bar Association a gift, which was a painting of Justice Vivian Bose. My lord, it adorned the office of the Solicitor General at that time. And, my lord, not only Justice Bose, Justice Hidayatullah, Justice Mudholkar, and then after that, my lord, we had Justice Sen, AP Sen. My lord, one cannot forget him. He was an extraordinary judge. And, my lord, and now we have two eminent justices, Justice Bobde. And, my lord, so we have had
Justice Shirpurkar also.
Justice B.S. Shirpurkar. My lord, one does not forget the bastions of glory in Nagpur. And, my lord, the archives, I wanted to tell some of the younger lawyers that they should go to Nagpur and visit the archives, my lord, of all the manuscripts of the judgments from Leonard Stone onwards, who was a Chief Justice in Nagpur.
And written judgments also.
And yes, my lord. And, my lord, I must also say the collected works of Dr. Ambedkar, which were published by the government of Maharashtra. The first chairman, my lord, of the editorial committee fortuitously happened to be Chief Justice's father. And, my lord, it's a marvelous compilation of the works of Dr. Ambedkar. And, my lord, he was magnificent in all fields of knowledge, anthropology, sociology, any form, law, of course. But, my lord, he was a magnificent.
Around 30 volumes.
Yes, now it's 30 volumes. My lord, I'm ready. Any questions any of your lordships have? May I conclude?
Yes.
May I?
You are so comprehensive that we don't have whatever we wanted to.
Grateful.
We are not left anything to be asked.
I'm very grateful.
Yes, Mr. Venugopal
Great research.
is there on.
I will start by saying it was a pleasure listening to Mr. Gopal Subramanian. I had not heard him for a few years now because he was away in England. But I have filed my written submissions, which for a change, my lord, consists of only 8 pages. And if your lordship should go to volume 2.
Most concise so far.
concise so far.
Yes, no. Only 8 pages. Volume 2.11. Pages 1291 to 1304, because it has 4 pages of, or 5 pages of annexures.
Yes, Mr. Venugopal, you can proceed.
Now, Your Lordship, will you please return to page 1293.
Yes, we have it.
I set out Article 163, where, my lord, the word required has been highlighted. And the meaning of the word required in paragraph 2 is that it is essential, needed, necessary, compulsory, mandatory, according to Collins Dictionary and Vocabulary Dictionary. Now, if it is mandatory, then except insofar as he is by or under the Constitution mandated to exercise his functions or any of them in his discretion. And therefore, my lords, there is no single provision in Article 201 and 200 and 201 which requires him to exercise his discretion except in the second proviso. And therefore, my lords, my submission to your lordships is, so far as the entirety of 200 and 201 is to be a mandate to him to act according to its terms. Now, my lords, the second proviso says that as opinion, in his opinion, and that is the only area of discretion. It has been pointed out to your lordships any number of times. Other than this, the phrase, my lord, in the first proviso is as soon as possible. And as soon as possible is a subject matter of a judgment which has not been quoted, which is in para 4, General Insurance Council versus State of Andhra Pradesh, 2007, volume 12, SEC 354. And if I may read that, para 8, use of the expression as soon as implies that there has to be promptitude in action. To do a thing as soon as possible means to do it within a reasonable time, with an understanding to do it within the shortest possible time. Per Assent J in King's Old County Limited versus Liquid Carbonic so-and-so Corporation. As and when and as soon as are almost synonymous. Whenever these expressions are used in respect of time and place, they denote contemporaneous notion as soon as and forthwith both are to be normally understood as allowing reasonable time, but latter is more peremptory than the former. But urgency is a hallmark of both expressions. Expression as soon as may be stretched to mean as soon as practicable. It has to be forwarded with promptitude. And it cannot be read as soon as convenient, as soon as possible. And therefore, my lords, I would proceed on the basis that it should be forthwith. Now, the reason, my lords, why I say it should be forthwith is because even money bills, which are of the utmost urgency, and I will show the provisions of the Constitution, which would make it very, very urgent, that to show that he has to deal with it as soon as possible. Even if the phrase is as soon as possible was not there, if belongs a money bill is to be presented to him along with the other bills, he necessarily has to deal with the money bill instantaneously, forthwith, because the consequences of not assenting to a money bill will be stupendous. There is no question, my lords, of his having any right whatsoever to withhold assent to a money bill, which I will presently show. And therefore, my lord, according to me, there are 5 choices. One choice, my lord, is to reserve the bills for the consideration of the president, which is covered by express provisions, my lords, of the Constitution. It's only in those cases that there can be a reservation.
According to, there are 5 choices.
It's 5 choices, not 4. And the 5 choices are, one, my lord,
Yes, one.
one is reference to, my lord's reservation for the president. The second is, my lord's, a money bill, which stands on a separate footing and independent of all the other bills. The third is, my lords, to grant assent. The fourth is, my lords, to refer, my lord, the bill with amendments to the legislature.
The third grant assent.
The grant assent, then to refer the bill back to the legislature with a message. And the fifth, my lord, is to withhold assent.
So you are supporting the solicitor. The fifth option.
To a great extent, I may, my lords, finally, because I believe, my lords, that so far the governor is concerned, he has to play a collaborative role in granting assent. Please see, my lords, Article 199, the definition of a money bill.
Yes.
For the purposes of this chapter, a bill shall be deemed to be a money bill if it contains only provisions dealing with all or any of the following matters, namely, A, the imposition, abolition, remission, alteration, or regulation of any tax. B, the regulation of the borrowing of money or the giving of any guaranteed by the state, or the amendment of the law with respect to any financial obligation undertaken to be undertaken or to be undertaken with state. C, the study of the custody of the consolidated fund or the contingency fund of the state, the payment of monies into or withdrawal of monies from any such fund. D, the appropriation of monies out of the consolidated fund of the state. The declaring of any expenditure to be expenditure charged to the consolidated fund. F, the receipt of money on account of the consolidated fund. G, any matter incidental. Now, your lordship should see the withdrawal of monies from any fund, consolidated fund, and the appropriation of monies are all part of a money bill, including the power of taxation. Now, assume, my lords, that a money bill is not assented to when it's presented and urgently assented to. The result is, my lord, the salaries of a huge population, which is more than, my lord, about 40% of the total budget of the country, they will not receive their monthly salary. And look at, my lord, the tragedy of it. Every single aspect of the definition of a money bill would indicate urgency. And that, my lord, will be also established if your lordship should be pleased to see Article 198, Clause 5, above that is just above the definition of money bill. If a money bill passed by the Legislative Assembly and transmitted to the Legislative Council for its recommendations is not returned to the Legislative Assembly within the said period of 14 days, it shall be deemed to have been passed by both houses at the expiration of the said period in the form in which it was passed by the Legislative Assembly. Now, what does this mean? Normally, my lords, a money bill has to be placed after being passed by the Legislative Assembly, has to be placed before the Council of States. Now, if the Council of States delays, my lords, dealing with it for 14 days, it will be deemed to have been passed by the Legislative Council, and, my lord, the money bill will be deemed to have been passed by both houses. This shows the urgency of a money bill. It will not, my lord, mark the delay of even, my lord, 14 days, more than 14 days. Now, would your lordships then conceive of a money bill being presented, my lord, to the governor, and the governor, my lord, sitting on it for as many as in the state of Kerala? I mean, they have not, the governor has not, my lord, withheld a assent to a money bill, but assume that
One bill he delayed for about 10 months.
one money bill. I'm told, my lord, that one money bill has been delayed for 10 months, but that's in a pending matter before your lordships. And therefore, my lordships, I will not.
We will not go into the facts of the individual cases.
No, please don't take it into account. Therefore, my lord, so far this is concerned, can we imagine, my lords, a money bill being withheld for a few months even, when salaries have to be paid month after month? And therefore, in those circumstances, there is urgency, my lord, which is read into Article 200 and 201, both by reason of the phrase as soon as possible and by reason of the fact that a money bill is referred to separately. Let me read, my lords, Article 200, which has been read a number of times, to show that when a bill has been passed by the Legislative Assembly, so and so has been passed by the houses, presented to the governor. Provide the governor as soon as possible, after the presentation to him of the bill for assent, return the bill if it is not a money bill, together with a message requesting the House to reconsider. Now, why is a money bill why is it mentioned separately? for the simple reason that the entirety of the provisions relating to money bill will show that no question of his withholding assent will arise. Great damage will be done to my lord the state if he withholds assent. And therefore, my submission to your lordships will be that both the phrases as soon as possible, as well as the existence of a money bill being mentioned separately, would indicate the urgency in dealing with the bills presented to him for disposal under 200 and 201 of the Constitution. Now, my lords, I come to the 5 aspects. That is, the reserving it for the president. Reserving it for the president, my lord, is only in the cases where the assent of the president is required. And that, my lord, those articles have been said, which have been mentioned to your lordships earlier. And if your lordships would look at plus para 10 of my written submission, I'll go back to the earlier paragraphs later, but because I'm dealing with the money bill, no, with the reference reserving for the president, para 10, the area of bills, your lordship said it.
Yes, we get it, the idea of the bill.
The area of bills being reserved for the consideration of the president would fall in one compartment, which power has to be exercised, which I'm sorry, would fall in one compartment, which power has to be exercised in relation to specific provisions existing in the Constitution. These provisions require or contemplate the assent of the president to a bill passed by the state legislature. This is evident if one looks at the proviso to Article 213, which relates to the ordinance making power of the governor, the proviso of which states, your lordships have not been, your lordship's attention has not been drawn to the proviso, provided that the governor shall not, without instructions from the president, promulgate any such ordinance. If the governor wants a state ordinance to be promulgated, he shall not promulgate an ordinance if, in regard to a bill containing the same provisions, would under the Constitution have required the previous sanction of the president for the introduction thereof into the legislature. Articles say 31A, 31C, 254(2), etc. That B, he would have deemed it necessary to reserve a bill containing the same provisions for the consideration of the president. 3. The act of the legislature of the state containing the same provisions would under the Constitution have been invalid unless, having been reserved for the consideration of the president, it had received the assent of the president. My submission, my lord, to your lordships is, this alone is an area where a bill will have to be reserved for the assent of the president. There is no question, my lords, of any other issue involving a bill being sent to the president. That, my lord, would violate the
Federal.
the federal, my lord, stature, the federal structure of, my lords, the Constitution. To take it. The federal structure, my lord, of the Constitution. Now, my lords, the judgment, my lord, of Justice Padiwala had said that there are other areas where, my lords, the matter may be referred to the president. Para 12, my lords. If I could read para 12. Under the constitutional scheme, neither the governor nor the president have adjudicatory powers in the area of the grant of assent under Article 200 and 201 of the Constitution. A power reserved to the judicial wing of the state. It would not be open to the governor or the president to adjudicate on the nature of the bill, to decide that it would undermine the Constitution or the fundamental principles of a representative democracy. The courts alone are empowered to adjudicate upon these issues. To that extent, my lord, I would say that Justice Padiwala has, my lords, given, my lords, certain areas to be submitted to the president. These are not matters which could be sent to the president because these will require adjudication. The powers given, my lords, to grant assent does not carry with it the power to adjudicate. And therefore, my lords, so far as if any other matter, other than if your lordship should just go to, my lord, para 11, line, my lords, 4, it is only a bill passed by the state legislature relatable to Articles 31A, 31C, 254(2), 255, 288(2), 304B, or 349. No bill not relatable to these provisions, which would require the previous assent of the president to give validity to the bill, would be sent to the president for his assent. It is in the interest, my lords, of the state to ensure that, my lord, so far as the governor is concerned, he would, my lord, reserve these bills for the assent of the president. And in their own self-interest, I would suggest, my lords, that the state council of ministers, when they forward a bill, my lord, to the governor, my lord, for his assent, if it is a bill which requires the assent of the president, there would be a legend, my lord, which is put on the bill at the end of the bill to be submitted to the president for his assent. It would be fully within the powers of the state legislature to indicate to the president, indicate to the governor, in the interests of the state itself, that these bills will have to get the previous assent of the president. Otherwise, my lords, the bill, if the governor straight away assents to it, the bill would be totally invalid and would be struck down. And therefore, my lord, to have a legend, this is not, my lord, part of a 163 advice. It is merely an indication to, my lord, the governor, that this would be in the interest of the state to refer to it. If, my lord, the governor has any doubts, and this I would come to later, there is a procedure by which all these doubts could be cleared. Now, my lords, after this, I would, my lords, go to the, so far as the learned, my lords, solicitor is concerned. He has, my lord, said that under Article 207, it is only with the recommendation of the governor that a financial bill can be introduced. He says this is a matter to be exercised in his discretion. I say no. And the Velluri Union of India versus Velluri Basavaya has clearly said that such recommendation is only on the aid and advice of the Council of Ministers. But your lordship should also be pleased to note, if your lordship will turn to Article 117, That's Article 117, my lords, is a corresponding provision to Article 207, so far as Union of India is concerned. Article 117.
Yes.
A bill or amendment making provision for any of the matters specified in subclauses A to F of clause 1 of 110, that is money bill, shall not be introduced or moved except on the recommendation of the president, and a bill making such provision shall not be introduced in the Council of States. Pari materia provision, my lords, to Article 207. Now, it has been accepted on all sides. I hope, my lords, the learned solicitor doesn't dispute this, that so far as the president is concerned, there is no area of discretion which is given to him under the Constitution, under Article 74. Unlike, my lords, Article 163. Therefore, my lord, the recommendation of a financial bill to be passed in Parliament will be introduced on the recommendation of the president. And necessarily this recommendation, since he has no area of discretion, has to be on the aid and advice of the Council of Ministers under Article 74. Applying this, my lord, to Article 207, I submit there is no question in regard to 207 saying President is bound to act on the aid and advice, but so far as the governor is concerned, he is not bound to act on the aid and advice of the Council of Ministers in recommending the introduction of a financial bill. And therefore, my lord, so far as the entirety of the argument based on a discretion being given to the governor in regard to any area other than the second proviso, my lord, does not arise. Now, thereafter, my lords, if you're, I have something to say, my lord, which may be perhaps in line with what the Union of India also wants to say. Now, there are 29 states, 28 states in this country, and 3 union territories, all of which have legislatures. Now, so far as these similar states are concerned, 29 plus 3, 31. 28 plus 3, 31. So far as 28 minus 5, that is 23 states, no whisper of going to court. There has been no problem whatsoever in the bills being assented to by the governors as and when they are presented. No such state or union territory has gone to court. Why? Because, my lords, so far as the governors are concerned, they are collaborative not in a bad sense. They, my lord,
They're supposed to be friend, philosopher, and guide. So collaborator is not a wrong word.
Yes. Friends, philosophers, and guide. Therefore, not they're only supposed to, what is it, British phrase of warn and advise and something. Therefore, so far as they are concerned, my lords, I say that there is an intimate relationship between the governor and the legislature. If your lordships look at the provisions relating to that, one, it has already been mentioned, Article 168, which is part of the governor is part of the legislature. Then he has to summon the legislature at the moment the general elections are held under Article 174. or on the first session of the legislature in each year. He has a right to address the legislature at any time he wants. And if there is two houses, then he is entitled to summon two houses for a joint sitting so that he could address them. He could send messages to them at any time under 175 and my lord under 176. Therefore, my lord, so far as he is concerned, he is intimately a part of the legislature, not merely, my lord, in a technical sense or a constitutional sense, but in an actual sense. He is as much interested in the success of the bills, which are, my lord, and can only be for the welfare of the citizens, or welfare of the people of the state, or, my lord, will be part of governance, and therefore, my lord, so and for the welfare of the people, and therefore, my lord, so far as he is concerned, how on earth can one treat the governor as an adversary? He is not an adversary. He has to go along, my lord, with every single bill, which we could have, my lord, intervened during the passing of the bill by sending messages saying, please consider this. And therefore, in those circumstances, when the bills come to him, according to me, he already would have a knowledge about the bills. He is bound to, my lord, therefore, take up the bills then and there. He does not have to, my lord, spend months studying the bills. Therefore, forthwith, as soon as the bills come, he first separates a money bill, grants assent, and thereafter takes, my lords, the bills relating to the articles which require assent of the president. He reserves all of them. Then comes the residue of the bills. He has got the three options there: grant assent, withhold assent, send it back, my lords, to the legislature with a message. Now, it is at this stage I have a suggestion to make, and this suggestion is based on the practice which was followed in the, my lords, Kerala by the then governor, who is now in Bihar. My lord, he would send for the minister when the bills are received by him, the minister who has introduced a bill, and would then discuss the bill with him. I have, my lord, an annexure, if your lordship don't mind looking at the annexure. It's in a pending requisition which was withdrawn with it before this is condition. But this was before Justice Narasimha 2 weeks back, which was withdrawn by me. If your lordship don't mind looking at page 1302. This, my lord, I would commend your lordships, is the only way in which the bills relating to grant of assent, withholding of assent, sending it with a message can be done. And if you're at page 1302, to show that this can be a practice if it followed, the chief secretary called on the governor and discussed the matter of the bill. The governor wrote to the chief secretary stating that whenever ordinance or bills are submitted to him for promulgation, he would like to have a briefing by the minister in charge of the department or any other minister who is well versed in the matter to be dealt with in the file. Then the second one, the principal secretary to the governor wrote to the chief secretary convening an order of the governor that whenever a minister calls on the governor to discuss matters pertaining to ordinance bill with the assistance of an officer, the minister may be accompanied by the secretary to the government of the concerned department instead of private secretary to the minister. Then on the right-hand corner remarks, the minister for animal husbandry met the governor, a private secretary, who is a senior government official, accompanied her. As a matter of practice, the personal staff of the governor interacts with the officers, etc. Then the governor wrote to the chief minister stating that there should be periodical proper briefing on governmental matters. Governor also underlined may be made for briefing him on the 11 bills forwarded to his office. And at the next page, 1303, the chief minister replied to the governor the next day stating, the points in which honorable governor requires clarification may kindly be conveyed at the earliest to the ministers concerned so that they can effectively brief the honorable governor.
Venugopan in any case will not be deciding the individual matters.
We cannot be deciding individual
We are
matters.
only answering.
No, I'm not asking a lordship to decide this case. I'm showing that a precedent has been set. And this, I submit, is the only manner in which a governor, my lord, can function. The governor, my lord, would not sit in an ivory tower, get a bill, and then study it by himself, or retain it for a number of months to study it, and then decide whether to grant or refuse. Now, what I have said, my lord, your lordship may kindly see in the written submissions, which is at page 16. Para 16. The practice followed in the state of Kerala has been that the governor sends for the minister concerned, who had moved the bill in the assembly, to discuss with him his concerns about the contents of the bill. The annexure to these written submissions was also filed before the court in WP so-and-so, show the number of times the governor sent for the minister to discuss the bills. Apart from the bills, which under the provisions of the constitution require the assent of the president, a matter dealt with earlier, all of the bills will be within the jurisdiction of the governor to grant assent, withhold assent, or to send the bills back to the legislature with a message. The practice in Kerala which is submitted is one which the constitution itself would commend, according to me, is to send for the minister who has moved the bill, unless the governor straightaway grants assent. After discussing with the minister, the governor, if satisfied, would grant assent, but in the alternative may decide to send the bill back to the legislature with suggestions for amendment. If, on the other hand, there is no agreement on either of these two counts, the governor would indicate that he intends to withhold assent. In such a situation, the Council of Ministers would forthwith advise the governor to grant assent, that is under Article 163, in which case the governor would have no choice but to grant assent under Article 163. In my view, it may not be appropriate the moment bills are passed for the Council of Ministers to utilize Article 163 of the Constitution and compel the governor to immediately grant assent in all cases, even without a discussion. To compel the governor through Article 163, at the beginning it is submitted, is not consistent with the high position held by the governor at the head of the state. So my suggestion is that what has been followed, this governor discusses it with the ministers, and then finally, if he is not following the two alternatives of granting assent, returning it with a message, then, my lord, he says, I am going to withhold. Then the 163 advice will be sent by the Council of Ministers, and he will be bound to grant assent. Therefore, there is no question of withholding assent in any circumstance. The governor has no such alternative. After the opinion expressed by this court in this reference, there may no more be any occasion for the state, if, my lord, what I have suggested is followed in all these respects, but the state parties to approach either the High Courts or the Supreme Court, as all states should follow the norm which has been set by the 23 states and 3 union territories with legislatures, where no disputes have arisen at all between the governor and states. Because the governors have been granting assent for the ask whenever the bills are presented. This approach would be most appropriate, as a governor being a part of the legislature and head of the state would collaborate. I mean, I'm not using it in a bad way, and ensure that the bills passed by the legislature are implemented straight away in the best interests of the people of the state. Even in the case of the president, one should realize that the president has no discretion and is really bound by the advice of the Union Cabinet. If the advice is to withhold assent, then the president, that is the Union Council of Ministers, would have to give reasons, and these reasons should be justiciable on the grounds of his acting ultra vires the Constitution. If he still, my lord, refuses to withhold assent and malafide, which may not arise, as held in S.R. Bommai and the Constitution bench in Rameshwar Prasad, so and so. What has been stated above is a comprehensive analysis of the respective powers of the state legislature, the governor, the president. By harmonizing the powers of these entities, there will be no impediment whatsoever to the bills becoming laws, thus upholding the interests of the state and people. And to therefore, my lord, to conclude, all that I would state is this. So far as the governor is concerned, there is no area of discretion except in regard to the second proviso. All matters covered by the articles mentioned, which require the sanction of the president, will be referred, my lord, will be reserved for the president. If the president has to act on the aid and advice of the Union Cabinet, there is no discretion. If he, my lord, wishes to withhold assent, then, my lord, the bill will be killed. And if the bill is killed, then the result of that is reasons have to be given. The reasons would make it, my lord, open to judicial review. And therefore, in those circumstances, so far as bills which are passed by the state legislature cannot, my lords, unless there is very, very good reason, cannot be thwarted. The governor is not there to subvert the functioning of the legislatures. On the other hand, he is very much part of the legislature and, my lord, interacts with the legislature from time to time. He has interests in the state as much as, my lord, the members of the legislature or the council of ministers. He will ensure that so far as these bills are concerned, they are assented to in the interest of the state. He has no power to withhold assent. Before he wants to adopt such a course, after discussing the bills with the ministers, the Article 163 will be used to forthwith ask the governor to grant the assent. Now, if this be so, every single bill will be passed, and the rare occasion where a governor withholds will be the subject matter of a court decision. This will ensure that the governor is not there as an adversary. The governor is there for in the interest of the state and the people, and to ensure the bills are passed. And therefore, in those circumstances, my respectful submission to your lordship is that this would be the best formula in the interest of the state. That's all.
Thank you very much, Mr. Gopal. Very brief.
My pleasure.
Yes.
Lord, I'm next in the sequence. Lord, my submissions are on behalf of the state of Punjab. What we have done is I'm addressing only on some constitutional aspects. To save time a lot, my friend Shadan will address on some legislative aspect, executive aspects. So, my Lord,
No.
We have
I'll make my submission.
We have,
Anyway,
Lord,
whatever he has to
we
say.
have embarrassed our colleagues not to.
All right. Whatever he has to say, I'll say it.
Yes. So we are
Correct.
we
I appreciate
are let down an arm, then
No, I did not. When we initially got the brief, we planned the work in such a way that there's not too much load on one person. But I appreciate your lordship. My lord, my submissions are now in 7 pages. They're lesser than Mr. Venugopal's, the shortest.
1 page.
By 1 page. So the shortest.
We hope that all your followers follow the same.
So I kept it to 7 pages. Now, my lord, what I've done is I've followed most of the arguments. The benefit of transcript is there. So to the extent possible, I have not made anything which has not been said earlier. My only request, suppose I'm repeating something, Lordship may just stop me and I'll skip it because time is short. Now, my Lord, my submissions are at page 1119, but my colleagues have been hard copies, I think.
So we already got it.
Hard copies, yes. My Lord, my first submission, hard copy. Just this,
So the bigger one.
I'll just,
Bigger.
my Lord, may I start? I shouldn't take more than half an hour, my Lord, maximum, because just 5 headings are there, so I should finish as fast as possible.
We are going to give 1.5 hours tomorrow to you also, because we are going to give 1.5 hours tomorrow also.
This side. Yes.
This side. Because the solicitor had eaten up your 1.5 hours, so we would like to compensate.
No, but this is, I would also, my lord, request that let him take whatever time it takes,
No.
because this is not a matter where, my lord, either of us can be constrained on time. My lord, we must assist your lordship fully and, my lord, in every aspect possible.
We are giving special hearing to everyone.
Yes, yes.
We are not rushing it.
I'm my lord, fully confident of that.
But only thing, my Lord, since by the time I've come around, most of the points have been discussed, so there is no point in
Repeating
saying something.
them.
Yes, unless something new, my Lord, there is no point in. Now, my Lord, my first submission, which is in my thing is, my submission is that the governor has no discretion. He has only 3 options. His discretion is to choose one of the 3 options. And the first question referred in the presidential reference is on presidential options, governor's options. Even the question 1 and 2 in the questions refer only to the options. Now, my Lord, my submission is Article 200 uses the word as soon as possible. Much has been said about it. I found that it has been used in 7 places in our constitution.
As soon as possible.
As soon as possible. As soon as maybe it's been used in Article 22(5). Actually, as soon as possible has been used in 242 statutory provisions, but most of them are as soon as possible laid before the legislature, that kind of thing. So I don't want to get into that. Where substantive as soon as possible is in 7 places. Now, my submission is, it has already been pointed out that 6 months was replaced by as soon as possible in the assembly. Although it's been
6 weeks.
6 weeks as soon as possible. Now, why do they say as soon as possible? I'm just putting my proposition for Lordship's kind consideration. Because the kinds of bills that may come before the governor may be of multiple types. There could be a simple amendment bill which doesn't require much time. It can be approved the very next day itself or the same time. On the other hand, there could be a complex bill which may involve matters falling under on list 3, which may involve a matter falling parliamentary laws already in place. So there the governor may take some more time to think. So as soon as possible doesn't mean an infinite amount of time. It depends on the context of the bill presented to the
Depending upon the facts and circumstances.
on the facts of simple amendment to some sales tax law doesn't take more than 10 minutes for him to see. Now it comes to as soon as possible means if the bill is complicated, he can take a week, 2 weeks. He may consult the
Advocate General or the other.
Yes, he may take that. He's part of the government, so he may consult the Advocate General, get an opinion or whatever. Now, my Lord, my submission is to accept the stand of the Union is to result in a constitutional paradox. And why I say that, Lordship will kindly see Article 200. Now, the argument is that I can withhold the assent.
Indefinitely.
Indefinitely. And what they say is, our side has argued that withhold assent must be read with the proviso. Withhold assent is only for the time taken to prepare a message, which in my humble submission could be the only possible interpretation, because withholding is like a pause. You're pressing the pause button and saying that, look, let me look at the bill. Is there something for which the governor wants to make a recommendation? Does he want to give a message? Now, if your Lordship kindly sees the proviso to Article 200, provided that the governor may, as soon as possible after the presentation of the bill for assent, return the bill if it's not a money bill, together with a message requesting that the House will reconsider the bill or specified provision thereof. So two parts are there. He can ask the House to consider the bill in entirety,
Or part thereof.
or he may say, look, some provisions are problematic, kindly look at them. And in particular, will consider the desirability of introducing such amendments as he may recommend. So Lordship will kindly see, the governor can say that, look, this particular provision is problematic. Why don't you think of this amendment? So he has got that much. So he can either reconsider the whole bill, reconsider the part bill, or he can go one step further and say, substitute clause 36 to mean something else. All that he can consider. Now, then the message goes back to the legislature. Now, please see the constitution. And when a bill is so returned with any of the three things, the House or Houses shall reconsider the bill accordingly. And if the bill is passed again by the House or Houses with or without amendment and present to the governor for assent, the governor shall not withhold assent therefrom. So whatever recommendations he made, even if they are salutary, the governor cannot withhold his assent. The paradox I'm saying is from what the union side is, if the governor applies his mind, gives a message, amend this provision or think about this provision again, and the legislature decides that yes, we still want to go ahead with it, then the president, the governor cannot withhold the assent. Now what they say is, it will be paradoxical to say that the governor can withhold assent without making a message. But once he makes a message and the legislature does not accept it, he cannot withhold assent. Lordship appreciates the point. After application of mind by the governor, if he says, please consider this, legislature says, I still want to go ahead with it, then he cannot withhold assent. But it will be absurd or paradoxical to say that I will not make a message, but I will withhold assent. That's my submission. That's why the argument has to be rejected. Now take a concrete example, which I have also been deeply concerned with so many years. Take, for example, in Maharashtra, we have this chronic problem of reservation for Marathas. All of us know it. I have appeared 3 times in 3 rounds, again and again. Now, a bill is prepared for reservation crossing the 50% limit. The governor may say, what are you doing? Indira Sani says 50% is the limit. Para 821 only says, except in far-flung states, etc., you can't cross the 50% limit. Yet the assembly goes and says, we want to cross 50%, we want to make it 16% more. Governor has no choice. Then it's for the legislature to say that because of Indira Sani, we are striking it down. But what I'm submitting is, because the Attorney General's submission also in the just Pardiawala was, he can examine the validity of the bill and make comments thereon. I'm saying, sorry, he cannot. And we got concrete example of Maharashtra. It's happened again and again. The governor cannot withhold assent. That's my submission.
According to you, like 111,
Yes.
if the president sends back the bill to the parliament,
Yes.
and if it comes back as it is,
Yes.
the president has no option but to
No
have
option.
assent. The similar analogy you apply even in
Exactly.
200. That's
Exactly. Because my lord, the governor is not a constitutional filter to say, all right, this is an unconstitutional provision. This is coming under list 3. If I still want to pass a law under list 1.
that according to you is exclusively reserved for the judiciary.
Yes. Yes. But the governor with his serious advice, he can say, please rethink. Please rethink. This is a problem available to you. That's my submission. Now, my lord, kindly come to the now the argument is he can give the assent straight away. He can withhold assent to make a message. My humble submission is withhold message is inextricably interlinked with that message provision. It's like Siamese twins. You can't divorce withholding a message without assent. Once he withholds the message, then he has to start working and take the trouble of preparing a message. He can't have a withholding a message, withhold assent and keep it as it is. Now, the last part is reference to the president. When can you refer to the president? What has happened now in some such states is routinely bills are sent to the president. And that gets indefinitely delayed. My submission is the scope of 200, that last part of reserving it for the consideration of the president, can be read with Article 213. That is not there in my note. Lordship may just make Article 213. In fact, I thought about, over the weekend, I thought about it. I added
230.
213.
Gopal was also-
Ordinance 213. Now, my lord, this ordinance power is there. If a lordship sees 213, if at any time, I read 230, if at any time, except when the legislative assembly of a state is in session or where there's a legislative council in a state, except when both houses of the legislature are in session, the governor is satisfied that circumstances exist which render it necessary for him to take immediate action. He may promulgate such ordinances as the circumstances may appear to him to require. So please pause there for a minute. The satisfaction of the governor is the satisfaction of the council of ministers. Sorry, may I proceed now? Yes. The satisfaction of the governor is satisfaction of the council.
Point. How much take on this point?
Me,
Yeah.
30 minutes, I'll take 30 minutes.
On this point.
On this point, just 3, 4 minutes more. No, we'll have it after lunch, no problems. I have
Mr. Datar was.
Lord, before lunch, I was at Article 213. And what I wanted to mention was that gives us a rough idea of the scope 200. Please come to Article 213. And I read clause 1. If at any time, except when the Legislative Assembly is in session, or when there is a Legislative Council in a state, except when both houses are in session, the governor is satisfied that circumstances exist which render it necessary for him to take immediate action, he may promulgate such ordinances as the circumstances appear him to require. Now, this ordinance is done on the satisfaction of the Cabinet of Ministers, Council of Ministers. They say matter is very urgent, ordinance has to promulgate, he promulgates it. But in the proviso, because the ordinance is going to straightaway become the law, there is no stage of bill being passed and so on. What happens is, provided that the governor shall not, without instructions from the president, promulgate any such ordinance if a bill containing the same provisions would under this constitution have required the previous sanction of the president for the introduction thereof into the legislature. He would have deemed it, number one, there are multiple sections, Mr. Subramanian cited them, 31A, 31C, where you require the previous sanction of the president. B, he would have deemed it necessary to reserve a bill containing the same provisions for consideration of the president. And C, an act of a legislature containing the same provisions would under this constitution be invalid unless, having been reserved for consideration of the president, it had received the assent of the president. So, in the case of an ordinance, the governor is cast upon a duty not to promulgate the ordinance if ABC are satisfied. Now, in Krishna Kumar, what they say is, if the legislature is in session, then he has no such duty. The governor need not wait for instructions from the president, assent to the president. Even if a law is repugnant, please see Krishna Kumar para 38. What I'm submitting is, as my friend Sadan also put it, a bill is not repugnant to any particular provision. A bill is not void. It's the law which is passed which becomes void. So at the bill stage, there is no repugnancy. The president or the governor can warn and say, look, if you pass this bill, this could be the possible consequence. If the state legislature goes ahead and does it, it faces the consequence of being struck down as either ultra vires Article 14 or 254 and so on. Now kindly come to Krishna Kumar's case, para 38. They emphasize this point quite well. Volume V37 at page 1403.
Where have you dealt with this point in your written submission? Which page?
Pardon me? No,
It
230.
before the weekend.
No, 213, I actually, yes.
He said that it's.
No, I said send the submissions. Then I was re-going through it. Then they said it's already been filed. So
Already said it's first.
sorry. I'm making an amendment. My apologies. So when I went to 213, then I saw Krishna Kumar also. Kindly see page 14103. Para 38, where they reproduce 213. I'll skip that. Lordship has got 14103. Now
103.
Yes. Para 38 starts with Article 213(1). V37. Then the Supreme Court discusses how these three conditions apply, and then the passage is important. May I proceed now? The first of the above conditions arises in a situation such as the proviso to Article 304B of the Constitution. Under Article 304B, the legislature of a state is permitted to impose reasonable restrictions in the public interest on the freedom of trade, commerce, or intercourse with or within that state, notwithstanding anything in 301, 303. The proviso requires the previous sanction of the president before a bill or amendment for the purpose of clause B can be introduced in the state legislature. An illustration of the second requirement, point 2 above, is provided by Article 200 of the Constitution, under which a governor is required to reserve for consideration of the president any bill which would, if it were to become a law, derogate from the powers of the High Court so as to endanger the position which it is desired to fill the Constitution. Situations where assent to the president is required, point 3, are illustrated by Article 254, where a law is made by the state legislature on a matter enumerated in the concurrent list is repugnant to a law made by Parliament. The state law will prevail only if and to the extent it has received the assent of the president. These three situations make it abundantly clear that while exercising the powers to promulgate an ordinance, the governor is not liberated from the limitations to which the law-making power of the state legislature is subject. Now please come to 200.
That's a, you missed two words in his opinion.
Where?
In his opinion, you missed.
No, 1 second.
1410.
Must be inadvertently.
No, 1 second. Wait a minute. Yes, which in his opinion, yes. Any bill which in his opinion were to become a law derogate the powers. I'm coming to that, in his opinion. Now kindly see. His opinion will be the president's opinion. Here in this case, which is reserved for the consent. Now, my lord, the point I'm trying to make is this. My entire submission is that the governor has only options, he has no discretion. That's my submission in terms of Article 200. And I make
He has to exercise either of the three options.
one of the three options. And
He has no discretion.
no discretion is my submission, and I'm deriving support from this because what are the limitations of the state? Same apply in an ordinance. But now kindly see, suppose a bill is potentially repugnant to a parliamentary law in list 3. A bill is potentially repugnant to contrary to a parliamentary law. Now, can the governor say that I will not assent to the bill because it is in the teeth of a parliamentary law? Now, my submission is the only ground on which the governor can suo moto refer the bill for the consideration of the president is the second proviso, where it derogates from the power of the High Court. So if a state legislature is doing something which is going to derogate the power, he need not act on the aid and advice of the state government. He can say that this is going to derogate from the powers of the president, of the High Court. Therefore, I'm referring it to the president. Second proviso is an exception to following the aid and advice of the cabinet. Now, kindly come to 254. Suppose, my lord, I'm giving an example, because if your lordship sees in the judgment of the two-judge bench, the reasons given by the governor was, if I pass this bill, it would lead to serious degradation in education standards. Many bills were educational bills. So he has given comments as to why he is not giving assent to the bill, because that bill will be contrary to entry 25 of list 3, or it will be contrary to entry 66 of list 1. All that is given in the two-judge bench. Now, my submission is, even if the bill in the teeth of it, I gave the Maratha reservation issue, even if the bill in the teeth of it is repugnant, what happens is my submission. Kindly come to 254 now. Kindly come to 254. Yes. Now, first come to 254.2, then I'll come to 254.1. Now, my lord, in most legislatures, when they make the law, it is often done with application of mind. They see the provisions, particularly if it's a concurrent list item. The first thing you will see whether this is going to be in conflict with a central law. That's the first thing you see. Now, let us say the state of Tamil Nadu wants to make a law which potentially could be in the teeth of a law made by Parliament. But it wants to have that legislation for the state of Tamil Nadu. What will it do? It will tell the governor that this is the bill I am raising. This potentially may be in conflict with the existing parliamentary law. It could be an Industry Development Regulation Act or an Essential Commodities Act and so on. Then the state cabinet tells the governor, please refer this for the assent of the president. Then it goes to 254(2). If the president gives the assent to the bill, then insofar as Tamil Nadu is concerned, though it is inconsistent with the law made by Parliament, it will be valid law for that state. That's why you got Stamp Act amendments, you got CPC amendments, you got Hindu law amendments and so on. State-wise amendments are there. Now kindly come to 254(2). Where a law is made by the legislature with respect to one of the matters enumerated in the concurrent list contains any provision repugnant to the provisions of an earlier law made by Parliament or an existing law with respect to that matter, then the law so made by the legislature of such state shall, if it has been reserved for consideration of the president and has received his assent, will prevail in that state. So the state legislature, the state cabinet can request the governor, please send this to the president for his assent so that this law in the concurrent list will prevail in Tamil Nadu or in Karnataka, or as the case may be. Suppose the state does not take the protection of 254(2), it makes a law. It says, I don't want the governor to refer to the president. Then it will run the risk of 254(1). Kindly see 254(1). If any provision of a law made by the legislature of a state is repugnant to any provision of a law made by Parliament, which Parliament is competent to enact, or to any provision of an existing law with respect to one of the matters enumerated in the concurrent list. So the state law can be repugnant to either a union list law or it can be repugnant to a concurrent list law. Then subject to provisions of clause 2, the law made by Parliament, whether passed before or after the law made by the legislature of such state, or as the case may be existing law, shall prevail, and the law made by the legislature of the state shall, to the extent of repugnancy, be void. But the point I'm making is, at the governor's assent stage, he cannot be a constitutional filter and say, no, I won't give assent to it because this law is going to suffer.
What you are saying is, state legislature is entitled to make a repugnant law.
An invalid law.
Valid law.
Yes.
Its survival depends upon operation of 254.
Yes. And again, you again get the thing that a law will be valid unless it is struck down by a court.
But the discretion, the question is the discretion.
Yes.
That the governor has under 213 for an executive legislation.
Yes.
Is unavailable for 200.
Yes.
The qualitative distinction is that under 200 it is passed by the legislature.
Yes.
Whereas under 213,
yes,
it is executive legislation.
Yes. Yes, exactly. Because it's an ordinance. Because the point is this, ordinance is made by the cabinet. It doesn't go through the assembly. There the bill may be defeated, may be passed, may go amendment, debate, discussion may take place. So here what happens, the governor effectively has an additional role to play to make a scrutiny and find in an ordinance. Will clause 1, 2, 3 apply? If 1, 2, 3 applies, then he will not promulgate the ordinance without the prior consent of the president, prior direction of the president. That's my submission. So 200, my submission is, whatever may be the nature of the law, because how did this matter come about? The reason the governor withheld the assent was he's saying that this Tamil Nadu Fisheries Amendment Bill is contrary to entry 66, is contrary to this law, contrary to that parliamentary law. My submission is no governor in the country can be a constitutional filter. No governor can take upon himself and pronounce upon the potential validity of the bill and decide. Because at the bill stage, it's a bill. I can, as Justice Narasimha put it, I can pass a good law, I can pass a bad law. I take the risk. 99% of the cases, my lord, normally a state legislature will not. That's why your lordship sees any constitutional textbook. The number of laws which are struck down are not even 2% of the total number of laws made. The court says there's a presumption of constitutionality. then the court tries to save the law, it may even read down the law. But to say that, the state legislatures will be some kind of a Wild West situation, they can make any law. If the governor is not a check, then there could be rogue laws being made. Is only a chimera, it's a mirage, it's not correct. On a constitutional principle, I can make a law in my competence, and sometimes what happens, the legislature may genuinely feel within my competence, but the court may say to the otherwise. We don't know. So that's my interpretation on Article 200. Now I come to the next part of my submission. Now my submission is, there is no bar in laying constitutional timelines. If a constitution is silent on a timeline, and if in the course of time, a timeline is felt to be necessary, courts can do so. I've just given one example. Kindly see 2.1.1 my written submissions, PLR projects, where in the context of appointments, I've just given the extract. Your lordships have said that the IB should submit its report within 4 to 6 weeks.
Paragraph
2.1.1, page 1121. Lordship will see in PLR projects, in the context of High Court appointments, the Supreme Court has said that the IB should submit its report within 4 weeks. Then how much time the central government should forward the collegiate within 8 to 12 weeks? Then how all those time limits have been sent back. Finally, it reiterates recommendation should proceed made within 3 to 4 weeks. Then kindly see 2.2. Dr. Rajendra Prasad, in his address to the Constituent Assembly, while moving the resolution for adoption of the Constitution, stated that the gaps that are in the Indian Constitution must be filled by developing proper conventions in due course. And I'll develop this convention point a bit later. So my submission is, if tomorrow, my lord, there is a provision, your lordship has done it on the statutes. In so many cases, at least as a tax lawyer, where no time limit is fixed for taking revision proceedings. In Bhatinda Power Project, Justice Sinha, in a very well-reasoned judgment, said that though there is no time limit, I'm putting an outer time limit of 5 years. If you issue the notice beyond 5 years, is that.
Restoration of land to Scheduled Caste and Scheduled Tribes Acts.
Yes, sorry, my lord.
So, Scheduled Caste and Scheduled Tribe Restoration of Lands Act.
Yes.
So, no timelines were provided for making an application for. The Supreme Court read it that though no timeline is provided, application has to be made within a period of 5 years from.
Yes, sometimes court says reasonable time, but lordship may see.
Now those acts have been amended.
Yes.
To overcome those judgments.
Raghav-Natha. First is Raghav-Natha, exercise of revisional jurisdiction under the land laws. And
Celebrated litigation of Gujarat High.
he celebrated Patel Raghav-Natha. And the court said when there is no time limit prescribed, it should be reasonable.
Reasonable. And that reasonable period has been read to be 5 years. Some of the.
I will go one step further.
Here in Raghav-Natha, it was said 1 year, but that depends upon the statute in question.
Number one, I would grateful. I'm saying sometimes the lordship may say go beyond reasonable and fix a time limit of 5 years, fix 3 years. Why keep it reasonable and keep it vague? Ultimately, the effectiveness of a law is its certainty and predictability. We are a large country of 28 states, 144 crore people are there. If Supreme Court lays down a law saying it is 3 months, 6 months, then there's complete clarity and certainty. Whether I'm in Meghalaya or I'm in Tamil Nadu or I'm in Karnataka. I'm just.
This court tried any number of times this concept of laying timeline.
Pardon me?
There is a season of medical season.
Yes.
The time when we have laid down the law, that within a fixed time, no further admissions, all admissions will come to an end. Rumapal's order.
Yes.
This has led to, you know, how much of litigation?
True. No, there are pluses and minuses.
Time after time, we have laid down timelines.
Yes.
And every year,
Timeline has
every year
never
there
worked
are applications
successfully
after
now.
applications for exchange.
Keep on extending time again and again.
It has
No.
created much more litigation than what it was earlier.
But not maybe in education.
Learning from our own experience
Correct.
also.
But not in education, it has created problems. In tax laws, the justice system has worked wonders. I mean, it could be from law to law. What I'm now submitting is The question is whether the court can impose timelines. My first submission is Supreme Court has imposed timelines from time to time
So you
in
can't
statutory
compare
provisions.
Constitution with statute also.
Pardon me?
Constitutional provisions stand on a completely
Yes,
different
my
footing from
submission,
that of a statute.
my submission, I agree, Lord. But the point is, suppose the constitution has not, in the initial draft, have not prepared a timeline. My humble submission is, in the case of constitutional interpretations, your lordship can always come to it. Take the basic structure from Shankari Prasad and Sajjan Singh, where you said that the power of parliament is untrammeled. That is the word used.
How much you
Because
have
of time.
courts to do this?
Pardon
You
me?
will have state governments filing applications saying
Yes.
that we need some more time. And these applications will go to under 226 before the high courts.
Yes, I'm not saying.
And on the other hand, you will have applications by stakeholders saying that the time is coming to an end. Don't grant more time or give it a mandamus. Our fear is we are dragging the court into a situation where the legislative process is getting completely monitored and controlled through the processes of the court.
Lord, can I?
We are not at any point of time saying that there is expediency and there is a requirement for legislative process to be completed within a time.
Lord,
But to fix it on a time schedule, the biggest risk court takes more than anybody.
Lord, I'll put, we are concerned with Article 200. Lordship will just visualize Article 200. We'll forget education, taxation, land acquisition. Let's take Article 200. Lord, the draftsman has made it as soon as possible. He has given a clear hint that as soon as possible. Now, I ask myself the question, if as soon as possible is creating problems in a working situation, where, as just Mr. Venugopal said, in 23 states it is done immediately, in 5 states it is taking 6 months, 7 months, 2 years, 3 years. I'm asking the question, my lord, what is the power of the court to say as soon as possible shall mean an outer limit of 6 months? What is wrong with that? And what the court has not said, you must do it within 6 months. That's not what division bench says. Division bench says, if you don't do within 6 months, you can come to court for redress. That's what the division bench says, the 2-judge bench. But I am putting a proposition for lordship's kind consideration. Is the court's power is not fettered if they feel that as soon as possible is vague, is leading to. Sorry, Murad.
We are only answering the question, so.
No, I'm not. So I'm just saying what in the light of what Justice Narasimha said, in a constitution should be what can be done in a statute. Can it be done in the constitution? My submission is if as soon as possible was not there, then it was a completely different cup of tea. But where Parliament has said as soon as may be possible, they've used it in 62 election of a president, 68 election of vice president. They've used it in Schedule 6. So whenever they said as soon as possible, suppose during the working of the constitution you realize
With respect to such an expression, the courts will still have jurisdiction.
yes.
You can't have a constitutional logjam. And
Yes.
just because those words are there, it doesn't mean that we have a problem.
No, I'm saying that I'm putting it this way, Malone. There is a law, which is the statute. There is an interpretation put by your lordship. The law is X, your lordship's interpretation is Y. X plus Y becomes the Article 141 law. Ultimately, the statute says something. Your lordships interpret that particular statute. Now, your lordship's interpretation on that particular provision as to what may be reasonable, what is the outer time limit, read both together becomes the law under Article 141. I am saying that this need not be Article 142 power at all. Suppose your lordship finds as soon as possible. I am asking myself the question, however complicated the law may be, do you require 3 months to give a message?
Even if as soon as possible was not there, still the governor would be expected to act in a particular time,
Yes.
in a reasonable time.
Yes.
Correct.
So
Even if as soon as possible was not there, as soon as possible says, all right, expediency is there. Without that, those words phrase also, there would be some expectation within a reasonable time and
Yes.
normal behavior
yes.
from a governor to,
Yes.
when a bill has come to him, he has to do something or the other.
I'm building upon what your lordship is saying. I'm saying that when the constitution makers made it 6 weeks, made it to as soon as possible, they always contemplated a definite timeline. It can't be kept endlessly pending. And why? Because I've been elected on a particular mandate. So tomorrow, Tamil Nadu government may want to impose prohibition. The governor may say, no, this is not a good law. I'm not going to implement it. You can't do that.
Can't
So my submission is,
test the validity of the law. The government cannot test the validity
Yes.
of the bill, yes.
so I'm
So
only
the
saying,
correctness of that bill.
yes, I'm only putting as a proposition of law. If as soon as possible, the highest court of the land interprets say, as soon as possible will mean a period of 3 months, a period of 6 months. I'm not saying there's anything unconstitutional about
It
it.
would be an urgency, it would require 24 hours for the governor to act.
Maybe, it may be. Some disaster is there, a tsunami takes
Correct.
place, some.
Whatever.
Or as Mr. Venugopalan put it, there is a money bill and there's an appropriation bill under Article 114. Now, money bill is under 111, appropriation bill is 114. Can you stop appropriation bill, pass the money bill and don't do the appropriation? Well, ultimately,
There
what-
could be situations, depending.
Lord, all these are components of a well-oiled engine, which is the government. Everything has to work together. You can't have one particular component not working in sync or harmony with the others. Otherwise, everything will break down. And what the Constitution contemplates is all of them work to the common goal of a particular government. A government has been elected. It has got the mandate of the people. The governor has to respect that mandate. That's all I'm saying. I'm answering my lord's question that can we impose a time limit in Constitution? My answer is yes. Lordships can. If lordships can lead basic structure into the Constitution, lordship has led substantive due process into Article 21. Why can't the lordship fix a time limit? If your lordships can go so far as to bring in substantive due process in 21, overrule A.K. Gopalan, why not? Then lordship first said 14, 19, 21 are separate. Then my lord said, no, all should be read together.
Trinity
These are
of-
all
Trinity of
Trinity,
19 and
yes,
20.
bank nationalization case.
Maneka Gandhi also.
Maneka Gandhi also. Yes. So I'm only putting to your lordship. I'm saying there's nothing wrong in the presidential reference to ask, can the court do so? Answer, the court can do so if it's necessary. And I'm asking, how many times has the court in the last 75 years, how many times has the court put timelines? Hardly 2-3 cases. In rarest of rare cases has happened. And then why should we complain about it? We should welcome it. Yes. Now throughout the country, all governors must give assent within 3 months. If they don't do, the litigant can go to the court. Is there anything wrong with that? Will heavens fall? Will entire administration go into chaos? Will there be a constitutional crisis? My answer is no, my lord. There is no reason to feel upset about it. You can only say on a principle, no, it is not, I will not be bound by any time limit. The Constitution doesn't say time limit, I will not be bound by it. That, in my humble submission, cannot be an argument. I'll go to the next point, my lord. Then my submission is, I've taken the plea of constitutional trust, which has not been taken.
The submission.
Yes, Roman 3. Lord, in 2.3, I'll read. Lord, over the weekend, there's an article by Professor Lon Fuller, where he talks of congruence. He talks of congruence. Congruence is the making of the law and the implementation of the law. If the law is implemented the way it was intended, it leads to congruence. If it is not done so, it leads to dissonance. So I'm just putting 2.3, Lordship may just see my proposition. Setting a time limit is essential for constitutional congruence. It makes explicit what was always implicit. What a Lordship said, reasonable time. Give it okay, 3 months, 6 months.
If it doesn't act, then come to court.
No, or I'm going to come to constitutional bypass. Go to 368. Say reasonable, delete as soon as possible. Then, Lord, Doctrine of Constitutional Trust. Lord, in Manoj Narula, I'll just read one passage from CY, 2014. It's at volume 45, V45, page 17984. Very nice passage from Mr. CY, late CY. Here he talks, page 17984. It starts at 17984 under the subheading Constitutional Trust. 17984. Basically, what they say is there is a belief that the highest constitutional functionaries will discharge their constitutional trust. 17984.
Starts from 17934. You are reading at page?
17984. And if your lordship permits me, my lord, I'll just read to 17983, para 82, which is the next point I made. I read para 82, Mala.
Para 82.
Para 82. May I read, no? Para 82? Yes. In a democracy, citizens legitimately expect that the government of the day would treat public interest as the primary one and any other interest secondary. The maxim salus populi suprema lex, not only to be kept in view, but also to be revered. The faith of people is embedded in the idea of good governance, which means reverence for citizen rights, respect for fundamental rights and statutory rights. This is most important, deference for unwritten constitutional values. Deference for unwritten constitutional values. And my submission is one value is
Exercise this constitutional power
yes,
reasonably is inherent in the power itself.
correct. Correct. Your Lordship is right.
Need not be superimposed.
No.
So if the power exists, one has to read.
Yes,
the power,
like a Lordship said in Article
the
2.
power
Yes.
that it must be exercised.
It's a power given in trust.
Time. And
Yes, yes. Lordship is right. So I'm just relying on the passage deference for constitutional values. Constitutional values means once a government is elected and it passes a law, it passes a fisheries amendment bill, you have to pass it. That's the end of the matter. Now please come to para 83, constitutional trust. My Lord, the Honorable Supreme Court reproduces important passages from Ambedkar, Samsher Singh. I'll skip all that. What is interesting is what the late jurist Mr. Sirwai wrote in para 88. I'll just read the extracted portion. While discussing about the successful working of the cabinet form of government, H.M. Sirwai, the eminent author of Constitutional Law, observed. Now I'll read this, my Lord. The Constitution does not guarantee that power would be wisely exercised by the executive. But as long as the political atmosphere remains what it is, the Constitution cannot be worked as it was intended to be worked. It has been said that the Constitution confers power, but it does not guarantee that the power would be wisely exercised. It can be said equally that the Constitution confers power, but gives no guarantee that it will be worked by men of high character, capacity, and integrity. If the Constitution is to be successfully worked, an attempt must be made to improve the political atmosphere and to lay down and enforce standards of conduct required for a successful working of our Constitution. So to lay down standards of conduct or lay down timelines for the effective working of our Constitution is the discharge of constitutional trust. This passage, Sirwai, is extremely important, my humble submission. Now I go to the next passage. Please come to 3.4. I have extracted from Sivanandam. This is High Court of Kerala. It was in a different context. But I'm relying on all these things to say that these timelines or these things which I've mentioned are nothing wrong, nothing unconstitutional, nothing warranting a presidential reference as such. In C.T. Sivananda was High Court of Kerala. I'm reading 3.4, my Lord. It was held in paras 44 and 45. In a constitutional system rooted in the rule of law, the discretion available with public authorities is confined within clearly defined limits. The primary principle undermining the concept of rule of law is consistency and predictability in decision making. A decision of a public authority taken without any basis in principle or rule is unpredictable and is therefore arbitrary and antithetical to the rule of law. The rule of law promotes fairness by stabilizing the expectations of citizens from public authorities. The principles of good administration require that decisions of public authorities must withstand the test of consistency, transparency, and predictability to avoid being arbitrary. So and so. Now, my Lord, what is important is the consistency and predictability in decision making. As somebody said, not taking a decision is also a decision. So the point is, once the bill is presented, if the Supreme Court has enforced a particular standard, I think it's completely in consonance with our constitutional values and our constitutional provisions to make the cabinet system of government work. Otherwise, the cabinet system fails. You have an elected government, they form a cabinet, but they can't pass a law. It's a logjam, it's a constitutional deadlock. Now, the very important point I want to make is this judgment of natural resources in my humble submission, is, with all humility, my lord, does not lay down the correct law is my submission. Natural resources. That was your lordship saw in the aftermath of the 2G case. It has already been cited. Where I feel the judgment is incorrect and it is contrary to in the Kerala Education Bill, is that it says that under Article 143, if a lordship is exercising advisory jurisdiction under 143(1), your lordships can evaluate and clarify another judgment, an earlier judgment. That's a very, very serious proposition to ponder. In an advisory jurisdiction under 143, can this court evaluate and clarify what is the law? I'm saying that the judgment is incorrect. It is per incurium because it is contrary to what Chief Justice Das said in Kerala Education following Lord Spence. And it is obitable because in that case, the Attorney General said we are accepting the 2G judgment. We are not questioning the correctness of the 2G judgment. The Lordship sees the questions. In fact, what we have done is kindly come to, where is the chart? Lord, my friends have prepared a chart of all the 15 references which have taken place with paragraph numbers, what is held, etc. Please see that they have done a very marvelous job. 1126.
Yes.
Page 1126. Volume?
Same
volume.
2.8.
Same volume. Oh yeah, after my, sorry. 112. It's after my written submission, sorry. Now, my lord, kindly see, from Indri Delhi Law's case, they have gone into what is the issue, what were the questions referred, what was answered. I am concerned with Indri Natural Resources, which comes at page 'There are totally 15 references, and each and every reference has been elaborately discussed. 1147. The Lordship knows, all of us know this 2G, all the licenses were cancelled. And the Supreme Court directed that the government should give spectrum not on this first come, first serve basis, but on auction basis. That was the. Now kindly come to the question that was said, referred to the larger bench, 5-judge bench under Article 143. Now please come to question 1, 2, 3, 4, where answered. Basically, they say auctions are not the only permissible method. There can be exceptions to auction. Now, if your lordship comes to the last column, last square in page 1147, lordship has got that?
Yes.
In the answers to the following questions. Lord, in this case, reference, the 2G judgment was annexed. And the correctness of that judgment was sought to be questioned. The judgment was an annexure. Now kindly see at the last row.
In the light of the statement.
Yes. Whether the judgment is required to be given retrospect so as to unsettle license issued by so-and-so, whether allocation and so-and-so, so-and-so, so all the questions were asked. In the light of the statement.
1147 bottom.
1147 bottom. In the light of the statement.
Yes,
of the Attorney General that the government is not questioning the correctness of the 2G case, the court declined to answer. And all the remaining questions were relating to the correctness of the 2G judgment and the effect of that judgment. And throughout, right up to page 1149.
The same answer.
Same answer. So, having answered that, they need not have gone into the scope of 143(1). Completely unnecessary. Now, kindly come to what they have answered. They discuss Kaveri 1, Kaveri 2. Please come to para 65. At 1151. We are therefore, sorry. Yes, this is on the scope of 143(1). We are therefore of the view that as long as the decision with respect to allocation of spectrum licenses untouched, this court is within its jurisdiction to evaluate and clarify the ratio of the judgment in the 2G case. For the purpose of this stage of argumentation, it needs little emphasis that we have the jurisdiction to clarify the judgment in the 2G case, irrespective of whether we actually choose to do so or not. Therefore, the fact that this reference may require us to say something different to that has been enunciated in 2G case as a proposition of law cannot strike at the root of the maintaining the reference. Now, what they say, this proposition, how they implement it is this. What they say is, we will declare a law contrary to what 2G said. We will declare the law, but we will not affect the decree. Kindly see, that's a very dangerous precedent. And that is discussed in para 60, yes. Yes. Para 61. From the aforesaid, he says it can't affect the decree. From the aforesaid, it is demonstrable that while entertaining the reference under Article 143(1), this court had analyzed the principles enunciated in the earlier judgment and also made certain modifications. The said modification may be stated as one of the mode or method of inclusion by way of modification without changing the ratio decidendi. For the purpose of validity of a reference, suffice it to say, dwelling upon an earlier judgment is permissible. That apart, one can't be oblivious to the fact of limited judicial review in the second judge's case, which is otherwise quite restricted, etc. My lord, my submission is, please come to para at page 1150. They say, kindly come to this last but one paragraph, the second limitation. Lordship has got that at page 1150, because this is seriously problematic, my lord. And subject to what the Lordship says, this cannot be the jurisdiction under 143. Kindly come to page 1150. The last but one paragraph, Lordship will say underline starts with in fact. Lordship has got it. In fact. In fact. Overruling. Yes, in fact, the overruling of a principle of law is not an outcome of an appellate jurisdiction, but a consequence of its inherent power. This inherent power can be exercised as long as a previous decree vis-a-vis inter partes is not affected. It is an attempt to overturn the decision of a previous case that is problematic, which is why the court observes that under Constitution, such appellate jurisdiction does not vest in this court, nor can it be vested by the President under Article 143. Then they say that we will make the point of law, but it won't affect the decree between the inter partes. My submission for Lordship's kind consideration is this. The jurisdiction under 143 is only to answer a question of fact or law referred to by the Honorable President to this court. My submission is the jurisdiction under 143 is not to clarify or evaluate. When you say evaluate, what do you mean evaluate? You're considering the correctness of an earlier judgment. With greatest humility, my lord, I will say the jurisdiction under 143 does not extend to this court evaluating or examining the correctness of a view. Just see what the consequence is. Indira Sawhney says 50% is the limit. Article 14 doesn't say 50%, 15 doesn't say 50%, 16 doesn't say 50%. You have fixed a percentage. They also go further and say 50% applies to promotion also. Now, can you have a reference to a bench of 11 judges to say, to evaluate and decide the correctness of Indira Sawhney? Answer is no. In case that judgment is wrong, then the remedy is Article 368. If that judgment has interpreted a ordinary statute, amend that statute, remove the basis. If it has interpreted the Constitution, then only remedy is 368. My submission is Article 143 is not a constitutional method to bypass Article 368. It will be a dangerous situation if the court says there is one judgment of 3 judges. It is, let's say, problematic. Use yours. So let us have a reference of 5 judges and we'll evaluate the correctness of that judgment. With great respect, my lord, that cannot be done under 143. If you go under 368, amend the law, delete as soon as possible, or say the governor will not be bound by any time limit. So I am only submitting the observations of this court, and I'll tell your lordship why. Even in the federal court, in fact, Mr. C, I was discussing with Mr. Subramanian at lunchtime. Mr. CY, I got a second edition. In re estate duty, what happened was very interesting. There was a case called in re levy of estate duty. AR 44 Federal Code 73. The Federal Court gave an advisory opinion. Advisory opinion under the Government of India Act. The High Court started following that advisory opinion as binding. The Federal Court says the High Court has fallen into an error in treating the advisory opinion as a binding principle of law. That comes in the Kerala Education Bill, and Kerala Education Bill says, yes, that is correct. And they cite Kerala Education, but let us not forget, in Kerala Education, they comment on the correctness of a federal court judgment. Supreme Court is supreme. Federal Court was not supreme. So Federal Court was subject to Privy Council. So in Kerala Education, Justice Das comments upon an observation of a federal court judgment. Nothing wrong with that. But my humble submission is, since your Lordship has got the occasion to see this reference, a presidential reference, in this case, we are basically testing the correctness of a view taken by a bench, though we don't mention it. We are saying, can you impose timelines and so on and so forth. I'm saying that natural resources is a wrong law to say that you can evaluate and decide the correctness of another judgment in that court. So indirectly, you're making an intra-court appeal when there is none. It can't be done under 143. Suppose the 2G judgment, suppose there's a judgment of 2G by 2 judges. It comes before another bench of 2 judges. Following the Dawoodi Bohra pattern, they can say we doubt the correctness of it. Let it go to 3, let it go to 5. Of course, that doesn't bind my Lord the Chief Justice. He can constitute any bench he chooses. But I'm saying that if it's a 3-judge bench, then answer is not to create a reference and evaluate the 3-judge bench. Either it goes the Dawoodi Bohra route or it goes by the constitutional amendment. That's my humble submission. Yes. Now, coming back to my submissions, I was at page 'Yes. Please come to 4 point. But at 11:24, I'll just read that paragraph and just to reiterate what I said. One, two, three, last 2 sentences. May I continue? 1, 2, 3, last 2 paragraphs, last 2 sentences, and I'll go on. I have only one more point on constitutional conventions. Constitutional trust. Sorry, constitutional, I have natural resources, yes. 4.1. In natural resources zones held under Article 143(1), the court has a jurisdiction to evaluate and clarify the ratio decedent in the judgment 2G case. It is submitted that this observation is both per incuriam and obiter dicta, because the Attorney General had repeatedly stated that the executive accepted the judgment in the 2G case. Further, the power to give an advisory opinion does not include the power to evaluate and clarify a judgment of bench of 2, 3, or even 5 judges. My submission is 143 is to answer a question of fact and question of law sent by the President. That's all. And that question of law cannot be a question of law that seeks to evaluate another judgment. That's my humble submission. Now, kindly see the next submission. I don't know if anybody has dealt with it. If so, I'll skip it. Number one, under 143(1). What can be answered by this question is questions of fact and questions of law. Questions of fact and questions of law, which the President has a doubt. And the Honorable President wants the opinion of the President. Lordship sees all the 15 references which I have given. Barring natural resources where the 2G was there but given up, nobody is evaluated or clarified whether it is in re sea customs, what's the scope of Article 285, or in the Delhi laws, what's the scope of delegated legislation? All these are questions of law which the president had a doubt and the president makes a reference. My submission at 4.2 is this, Lord. Now, question of law is there in CPC, substantial question of law. In every tax statute, there is a question of law. High Court only on questions of law. And I was surprised to note, my Lord, that under section 100 before 76, there was no reference to question of law. That was only in section 109. But in 100, they introduced substantial question of law. Meenakshi Mills, Justice Venkatramaya has discussed at elaborate length what is question of fact, what is question of law. I am not on that. I am on the point that if the Supreme Court has delivered a judgment on a statutory provision or a constitutional provision, then that is a law declared under Article 141. My Lord will see the presidential reference in this case. The questions referred are issues framed by the two-judge bench in this very case. For example, the first question which is there, what are the constitutional options? Issue number 1. If your Lordship takes question number 2, it's issue number 4. So I'm putting a proposition of law. If the Honorable Supreme Court, because it's a what they call polyvocal court, you can have bench of 2 judges, 3 judges, 5, but whatever it may be, it is Article 141. So my submission is, if a particular bench has framed an issue, answered the issue as a question of law, then on that point 143(1) will not arise, because there is no other, because the president has to only follow that judgment, that's all. Or parliament has to amend the constitution or amend the statute, whatever it may be. So I'm putting forth the proposition that 143, the Lordship sees that section, just 1 minute. Yes. My friend puts it very, Sadan put it better. Sorry. My friend Mr. Farasar put it quite well. He said, once the question of law is answered, it's no longer a question, it is the law. Then there is no question of law. It says, if any time it appears to the question that a question of law or fact has arisen or is likely to arise, if such a nature. If a question of law has arisen and it has been answered by the court, then 143(1) will not. Sorry, man.
Yes.
Yes. I'll just go back to my submissions. No, my Lord, because since your Lordship is now laying down the law for all future times to come, if there is a declaration of law by the Supreme Court under Article 141, that should not be a ground for a reference, is my humble submission.
We did not come to argue as a preliminary objection that the reference is not maintainable. We have been hearing on all the 13 questions.
No, I was told your Lordship said did not want to go to maintainability. So I'm not saying it's not maintainable.
No, we have what on the maintainability?
Nobody argued, Manoj, on that side, this side.
All
It
right.
was argued. I didn't want to interrupt, but
Yes.
it was raised.
No, I'm only saying that the reference is there. What I'm submitting is, if the question.
You are not on maintainability.
I'm saying that if one question referred to the Honorable Court has been already answered in a judgment, it can no longer be a question of law. That's my submission. So suppose there are 12 questions, hypothetically, and 6 questions have been answered in a judgment. Those cannot be the subject matter of 143(1) is my question. Because there could be some questions which are open. That's why I'm not getting into, but I don't want to be hyper technical. Today we have to answer a very important issue on reference jurisdiction. And whatever law Lordship lays on is going to be there for the next 15, 20 years. That's what I'm submitting. So my submission is, because what the president refers are questions. And those of us who have been, again, going back to tax, old 256 Lordship, no, when Lordship were juniors at that time, there used to be a reference jurisdiction. High Court did not have appellate jurisdiction. It will go to the High Court for the reference as an opinion. Based on the opinion of the High Court, assessment order is then passed. And the Honorable Supreme Court has said in Lala Bansidhar's case, if there is a reference, then there is no question of any merger and all that. The advice is given by the reference answered by the High Court and the assessment is complete. And even though the matter goes to this High Court for a reference, the tribunal continues to be seized of the matter. It's not that the record has gone to the Superior Court like a first appeal. So High Court answers the question of law,
Then after a final order is passed.
and then assessment order is passed in terms of the assessment, unless it's modified by the Supreme Court. So my humble submission is, what is the meaning of 143 questions of fact and questions of law? If it's a question of law answered, then that can't be the subject matter of 143(1). Now kindly see, my submission is, para 4.2, once the president will require an opinion only on a question of law on which there is a doubt. 4.2, my lord, just 2 minutes. Once a judgment is delivered, the only way its basis can be challenged is by a constitutional amendment, Article 368. That is slightly, if the judgment is on a constitutional article. That's why I said, Indira Sani, the Supreme Court said 50% is there. They also said 50% will be for promotion also. What did Parliament do? 77th Amendment, 16(4)(a). Promotion will not be 50% won't apply to promotion.
Indira Sani said that the reservation will not apply to promotion.
50% limit applies to promotion also.
Indira Sani said that
No, not promotion. It's not apply to promotion. So it will apply to this thing.
it
Then also-
applies only to appointment and not for promotion, and therefore
Yes,
the
16(4)(a)
first
came.
amendment.
16(4)(a). 16(4)(a) amendment came. Similarly, carry forward rule. They said the reservation will not take into account that carry forward rule. That also was, so I'm only submitting, you could not evaluate and correct
It's for the Parliament to correct, according to.
for the by constitutional amendment.
It's by constitutional amendment.
Yes,
If they want to overcome the judgment of the revision bench, they can't do it by way of reference.
because it's a
The
360.
only way available to them is by way of the constitutional amendment.
Because they've interpreted the constitution. That's why the Maratha reservation is we succeeded on 2 rounds, because it can't be done by a Maharashtra legislative act. That 50% limit can't be crossed by a Maharashtra law. Now again, my friend argued on this adding to the list of scheduled castes.
That is again going on before Bombay.
Which one?
Bombay High Court, Maratha reservation.
I concluded my arguments, Varun. No, again, 4th round is coming after the recent. We both of us were there, both of us were there in Bombay and then Supreme Court.
Full bench.
Then, my lord, it came to Jayashree Lakshman Patil here. And where, my lord, once the bench held that under 342, the state can't amend the list. Again, the constitutional amendment.
What is your answer to 145(3),
Huh.
which requires that any question with regard to interpretation of the constitution
Yes.
has to be heard minimum by 5 number of judges?
My submission is, please see the provisor to that. Please see the provisor to 145. Yes.
It's provided that.
Yes, Lordship will, my friend says, please read 145(1). Yes, that says yes. Now kindly come to 145(2). Subject to the provisions, the articles may fix a minimum number of judges who was to sit for any so and so, so and so. 3, the minimum number of judges who are to sit for the purpose of deciding any case involving a substantial question of law as to the interpretation of the Constitution, or for purpose of referring any reference under 143 shall be 5. Now please see the proviso. Provided that where the court hearing an appeal under any of the provisions of this chapter other than Article 132 consists of less than 5 judges, and in the courts of hearing of the appeal, the court is satisfied that the appeal involves a substantial question of law as to the interpretation of this Constitution, the determination of which is necessary for the disposal of the appeal, such court shall refer the question for opinion of law constituted as required by this clause for the purpose of deciding any case involving such cases, and shall on the receipt of the opinion dispose of the appeal and so and so.
So therefore, then the court was required to refer that question to.
No, if the court is satisfied, my submission is first twofold. If it's a writ petition under Article 32, and there's a bench of 2 judges before whom the challenge comes, there are any number of cases where this honorable court in sitting in 2 and 3 have struck down a particular law under article constitutional provision. They've interpreted the constitutional provisions. I can give any number of cases it has done so. So what I'm saying is under 145, the minimum judges who are to sit for the purpose deciding any case.
Struck down the constitutional provisions.
Yes. Or it has upheld the provision. They've heard constitutional issues. The entire issue of service tax, All India practitioners case. It was heard by 2 judges. I'll give so many other examples. The cooperative society was struck down by 2 judges. Remember, this 145.3 has come at a time when the Supreme Court used to hear all matters en banc, 5. Now, over a period of time, it's not.
Cases, request was made that refer it to the larger bench.
Which one?
Here, the learned AG did make a request.
But if it is not, the way I referred to the proviso was, the court hearing the appeal, let's say the appeal can be an Article 32 petition. Suppose the reason is made that this matter should be referred to 5 judges. And the court says, no, not necessary to refer to 5 judges. Jai Shri Lakshman Party, 3 judges, right?
5 judges.
No, no,
5 judges.
which are heard by, Nageshwar Rao, Hemant Gupta and 3. I think your lordship also know.
It's 5.
Hemant Gupta and Ravindra.
It's 5 judges.
Ravindra.
Five judges.
It is
One judgment.
appeared through virtual
The
hearing
next
during
round,
COVID.
the next round came. What we argued was this was thought to be referred. We argued that since the matter is already concluded, though it involves interpretation, there is nothing further to answer and so on. So I'll give any number of cases where 2 judges benches, 3 judges benches have heard matters of constitutional interpretation. And in any case, at best, it can be an illegality or fatality.
Ashok Kumar Thakur, which is 2007, 6 SEC page 1, if I'm not wrong. Before it was
Last
referred,
number.
right, 2 judges to 5 judges. The 2 judges stayed section 6 of the reservations, Central Reservations Act. By 2 judges.
And I would submit, Brother, to answer 145.3, my proposition is this. Sorry. I'll put for lordship's kind consideration. 145.3, over the years, 145.3 is not taken as a necessary mandate. Not constituting a 5-judge bench is not an illegality or irregularity.
When a specific request is made to a bench, that these matters requires interpretation of constitutional provisions. Anyway, we are not sitting in an appeal. So
Yes. They go for a review. Go for a review. You review curative, whatever it may be. No, I'm only saying that you can't take up at now in 2025 and say a bench of 2 judges decide a constitutional provision. They have not struck down any particular provision. They've only said, please see the judgment below. What have they said? They've interpreted, lordship see the particular judgment also. Have they struck down any particular provision? No. They have said it should be done in 3 months. If it's not done in 3 months, you can approach the court. And kindly see, and deciding
petitions to the law. You can't complete.
But one more point I'll raise, since we're on a principle law, not put this particular judgment. Now the question is, suppose tomorrow I file a writ petition challenging a particular provision, or from the Madras High Court or High Court it comes on appeal. It involves a question of law. I raise an objection saying it should be heard by a bench of 5 judges. A bench of 5 judges. I raise an objection. Suppose the court feels that yes, it requires interpretation, yes. Now in this case, it should be a case involving a substantial question of law as to interpretation of the Constitution. Suppose the court is going to rely on a series of precedents and decide, it may feel it's not necessary to go to 5 judges. I've got enough case law to take a decision on that particular point of time. I'm only saying that let's not create a situation. Otherwise, we will not be able to decide many matters because everything will wait for 5 judges.
yes.
Everything will be for 5 judges. But I don't want to go on this fear psychosis. I'm only submitting that there is a practice of this court of 2 judges and 3 judges deciding cases of constitutional law. Here it talks of involving a substantial question of law as to the interpretation of this Constitution. My humble submission is, this court has only said as soon as possible is equal to 3 months. That's all. Nothing. It has not struck down some great constitutional provision by 2 judges. No. I can understand like Indira Sani decides multiple questions by bench of 2 judges. Yes. That's my submission. Yes. How do you deal with the objection of validity? Yes. And one more thing, my lord. In para 239 of the judgment, his lordship says that our interpretation is not to be taken as an interpretation of 200, but to be considered as guidelines to attract judicial review. I'll read that passage, para 239 of the two judge bench. Any time limit in the exercise of powers in terms of Article 200 of the Constitution should not be construed as timelines laid within the edifice of the provision, but should be understood as timelines that serve as a lodestar for the purpose of exercise of judicial review by the courts, a benchmark tool to aid and enable the courts to ascertain if any action or malfeasance has occasioned the exercise of such powers. So, but I'll just go to the other part. But then your lordship will have to frame a question that if a question of substantial import of constitutional interpretation comes, substantial question of law, constitutional, should it be heard by a bench of 5 judges? If that is the answer, then we are going to have a question where there will be a threshold limit first deciding. Is there a substantial question of law? If the answer is yes, it has to necessarily go to 5 judges. If your lordship feels that should be there, so be it, my lord. Now kindly come to, but I'm only submitting that could lead to serious problems of areas in the long run. Now, kindly come to 4.3. A chart is annexed which sets out the details of 15 references under Article 143(1). There has never been a reference to take up a question of law which has already been answered. Chart containing details of all 15 references is marked as Annexure 1. Now I come to my final submission on constitutional conventions. Now, my lord, the Constitution doesn't provide for everything. Practice adopted by constitutional functionaries, be it the judiciary, the legislature, the governor, the president, that they set out conventions which are to be followed. Our Supreme Court has said a convention taken over time is as good as constitutional law. Constitutional convention also amount to constitutional law. Now I'm asking myself the question. Is there a constitutional convention of approving a bill at the earliest opportunity? My submission is Article 111 and Article 200 are mirror images, barring minor differences. Both talk of assent to bills. They don't talk of scrutiny of bills, examination.
You have already argued that.
No, I'm saying constitutional convention. So I'm just quoting a passage from May, and I'm going to say that there's a convention. I'll put this properly, my lord, the Chief Justice will ask the question. I'm saying that if there is a constitutional convention of the president giving assent to the bills, and very, very few examples are there where it has been withheld for some small period of time. If there is a convention under Article 111 to approve the bill at the earliest, as soon as possible, which is also a term used there, the same convention must apply to Article 200 also. Because what the governor is to the state, the president is to the country. In a federal setup, the governor performs the same role as my friend put it, I'll show his passage later. In a Westminster form of government, in a presidential form of government, the president is also the head of state. But in a Westminster form of government, there's an elected government and there is a head of state, a symbolic head of state.
Titular head.
A titular head or a titular head, like the queen or the monarch or the president or the governor. He is not just for a mere symbol, because governments will come and go, but the president is there, the governor is there. He symbolizes the state. He is the head of the executive. He symbolizes the state. He becomes the supreme commander. All those things come which have followed the British pattern. Now I'm going to come to two passages from Erskine May's 1924 edition. It is not there now because now they have passed a Royal Assent Act in 1967. But yes, but what is the convention? Please come to para. Very interesting passage from Erskine May. At para 1.5, just two more passages and I have done. .5. Page 1120. The constitutional provision, Lordship has got it, all your Lordship, page 1120. The extract from May is very interesting. The constitutional provision to grant assent has been borrowed from the Westminster model. The royal assent is to only complement and perfect the law. The following passages in Erskine's Smith's Treatise of Law, Privileges, Proceeding, Usage in 1924 are important. Page 430. But I've extracted that page also. When bills, either public or private, have been finally agreed to by both houses, they only await royal assent to give them, as Lord Hale says, the complement and perfection of a law, and from that sanction they cannot be legally withheld. Now 433 is even more important. The form of words used to express denial of royal assent would be le roi s'assuera. Assuera means the king withholds, the king is going to consider. That's the French term used before 1967. The necessity of refusing the royal assent is removed. Now this is very important. The necessity of refusing the royal assent is removed by the strict observance of the constitutional provision that the crown has no will but that of its ministers. Aid and advice. The crown has no will but that of its ministers, who only continue to serve in that capacity so long as they retain confidence of power. This power was last exercised in 1707 when Queen Anne refused assent to a bill for settling the militia in Scotland. Now, we're coming back to my page on constitutional conventions. I just read that passage and I've concluded now. Para 5.1. Just read this. Just 5 minutes more. The grant of assent by the president is set out in Article 111. Barring very rare exceptions, the president has followed the UK pattern of not withholding assent. This practice of president assent not being withheld must be followed by governors. There cannot be one constitutional convention for the president and other for governor when the ambit and scope of Article 111 and 200 are the same. Conventions play an important role in understanding the real purpose and function of a constitutional provision. I've given the footnote, but I won't trouble your lordship. I've given the para number also. British conventions assume special significance in understanding the parliamentary system of India, since it's akin to the parliamentary system of England. In the second judge's case, it was held that the written constitution cannot provide for every eventuality, and hence the gaps present in the constitutional provisions are to be filled by constitutional conventions. This honorable court also held that there is no distinction between an established constitutional convention and constitutional law, as they are both binding in the respective fields in which they operate. When it is established that constitutional convention exists, it would be enforced in a manner similar to constitutional law. Now, UNRO's case is important. Article 111 and 200 place a president and governor in the same position as the king/monarch of England. In UNRO versus Indira Gandhi, it was held that Article 75(3) has to be interpreted with the conventions which prevailed at the time the constitution was framed. Please see that judgment, Lord.
That was already been read to us.
UNRO para 3. All right. So I'm submitting that if 75(3), if the convention of 111 is not to withhold assent, please apply the same convention to 200. Because what convention applies to one provision must also apply to a pari materia provision of the constitution. That's all. Now, Lord, from Mr. Shadan's two passages. Yes, he wanted to. Two passages.
Your chart shows 45 minutes, but you already taken 80 minutes.
Sorry, but he has one interesting passage he mentioned about one book. I just leave it again. Just take 2 lines I can show because he wanted to. I'll read that one. What just permit me. Please come to 1155 with the same page and I'll stop with that. Yes. Please come to page 1156.
He's not shameless.
A nominal head of state, Lordship's got it? A nominal head of state, unlike the head of government, has only 3 powers. Page 1156, para 5. Then extract is there. Please come to para 1157. And the bold portion, just 3 lines I'll read. Lordship has got that?
Yes.
To state the matter shortly, by Walter Bajeho. To state the matter shortly, this is the role of a sovereign. The sovereign has under a constitutional monarchy such as ours 3 rights the right to be consulted, the right to encourage, the right to warn. And a king of great sense and sagacity would want no other. He would find that his having no others would enable him to use with singular effect. He would say to his minister, the responsibility of these measures is upon you. Whatever you think best must be done. Whatever you think best shall have my full and effectual support. But you'll observe that for this reason and that reason you propose to do is bad. And for this reason and that reason you do not propose is better. I do not oppose. It is not my duty to oppose, but I observe that I warn. So the role is the right to consult, right to be consulted, the right to encourage, the right to warn. Therefore, my humble submission is, my lord, as far as this reference is concerned, all these questions have been answered. And the points that have been raised, since they're already questions of law answered, these questions need not be answered under Article 1, should not be answered under Article 143(1). Particularly that in the natural resources is the most problematic judgment of saying under 143, a referral bench, an advisory bench can evaluate and clarify a law would be very dangerous, deeply obliged.
Take about 10 minutes.
Only one counsel for one state.
I'm appearing for internet also.
No, we have
10 minutes.
If you permit intervention of one political party, we'll have to have
Only one intervention is allowed.
no.
We have not yet started.
Not yet, my lord.
They are not hearing Mr. Gopal Singh.
My lord, I have 5 minutes, I'll place it.
We are no, if we permit one political party.
New facts, my lord, nothing else. My lord, other,
No facts, we are only.
on the law, my lord.
Let the states complete. The state of Telangana has yet not been heard.
My lord, after them, then I'll make my submissions.
We don't know. We
5 minutes, my lord, I'll place it, my lord.
We have a sequence which we've been following, Manoj.
Sorry.
So Reddy is supposed to be next. We are following.
Mr. Wilson, but then he's been shown as an intervener. So,
Mr. Reddy is next.
My lord, on
As per the
our
sequence.
side, we have requested many interveners not to come.
yes.
My lord, I'm only placing, my lord, two discussions, my lord, constitutional issues, my lord.
But
Article
we have heard
175.
the state of Telangana extensively.
My lord, 175, my lord, how-
Tamil Nadu extensively.
my lord, my lord, my lord, but
Let
because
the
of
state, let the state of Telangana address.
yes,
Let
Lord,
the
I'll
state-
wait, my lord. Lord, as per sequence, my lord, my name is there. Lord, we are.
We know, but then we are not
No
allowed.
reason, my lord, for this reference.
We are not allowed the intervention application.
But we are the sole reason for this reference, my lord.
Maybe, but then state of Tamil Nadu has opened the argument.
We thought, my lord, some
No, no.
important points, my lord. which-
One political party, then we'll get hundreds of political parties.
Lord, one intervention is already allowed, my lord. That's why. Sir Gopal Sankaranarayan is appearing for them.
Who?
Sir Gopal Sankaranarayan.
Five interventions.
5 minutes, that's all, my lord. 5 minutes.
For the Gopal sir and
It's
one for my.
Five
Five
minutes.
interventions were allowed on the first
Allowed
day.
already.
We have all been waiting patiently. Somebody, because the opportunity has been lost, is now coming on an
No, no,
intervention.
sir,
That's
I'm
what is
also there,
happening.
sir, for the day one, sir.
No, no, but
Since
you
8 days,
saying
we are
that the
waiting
case
for-
arises because of state of Tamil Nadu. The arguments were opened by state of Tamil Nadu and we have heard extensively for more than a day.
First we'll complete states, let him start.
Let the
five
state complete.
Lord, I'll leave it to your lordship, Lord, I'll wait if your lordship permits me.
We'll look, first let the states be argued.
Yes, no, I'll wait, my lord, I'll wait.
I have filed my submissions. So, after the submissions were filed, some part of this contentions have been covered by Mr. Datta. So I'll try to, my lord, skip over those parts. The lordships would have the index on, my lord, on page 1318. The short submissions I want to make, my lord, are on these 6 issues. My lord, first, on the aspect of advisory. I'm sorry, my lord.
And where is yours?
My lord, volume 212.
12, page 1318.
Yes, no, starts from 1317. But at 1318, my lord, I've just indicated the headings under which.
Yours starts at 1317.
That's correct, my lord.
Before that, it is probably Mr. Wilson's note, 1309. The same compilation.
Yes. Yes. Note 1318, I've just indicated the headings in which I wish to assist your lordships very quickly. My lord, at page 1320, My lord, is my submission that I wanted to make to your lordships on advisory jurisdiction. My lord, the first submission I wish to make is that the advisory jurisdiction is more expansive than a regular judicial review. My lord, because normally, my lord, when your lordships are undertaking judicial review exercise, my lord, then your lordships are constrained by the separation of powers. Your lordships may be little wary of stepping into, my lord, a legislative area or an executive area, because, my lord, those are separate organs. But in an advisory jurisdiction, what happens is your lordships are now invited by the president, asking your lordships to give legal advice on what the president and the governor should do ordinarily, which is done in the legislative or executive space. But one of the questions is, can a bill be commented upon before it becomes law? My lord, your lordships in special courts, my lord, matter has actually answered this, because contentions were raised by some people saying that if it is a bill, it is a property of the house. It cannot be touched upon by the Supreme Court until it becomes a law. My lord, your lordships, my lord, in this judgment of 1979, volume 1 SCC, page 380, I'm not reading this. My lord, the only page number, my lord, is 3661. Your lordships have answered that even a bill, before it becomes a law, while it may be in the legislative space, if the Honorable President has sought a reference under Article 143, but then on aspects on the legality of the bill, since they are asked by the Honorable President, they can be commented by the Honorable Supreme Court. So, if my lords would kindly have page 1312.
Where is that judgment?
That judgment, my lord, is at page 3661.
Mr. Datar had cited it.
Volume 5.9.
Which one?
This is special courts reference.
Chief Justice Chandrachud's passage.
Yes.
But I'll invite my lordship's attention because I just have a couple of points to make on this. Now at page 1320, my lord, in this first part, my lord, this para 1.1 to 1.4, 1.3 are the, my lord, points I just made for your lordship's consideration. Since it is at the invitation and indication of the Honorable President requesting this Honorable Court to explain as to what is expected of a governor or a president under Article 200 and 201, my lord, your lordships would now be advising, my lord, the President and, my lord, through the President to the governor as what is to be done in terms of the expeditious matter in which they will have to conduct the matter. So normally in a judicial review, the two-judge bench in state of Tamil Nadu possibly was wary. It was cautioning itself and it was saying that this time limit is imposed by us only to act as a lodestar for any judicial review action to be filed. But my lord, now the doors have been opened wider because, my lord, if your lordships looks at this in a sterile, non-confrontationist manner, your lordship said facts will not be looked into. Pure constitutional principles, my lord, will guide your lordships when your lordships are answering this. So, my lord, if I have to now treat this, my lord, as a pure constitutional question that is placed before the Honorable Court, I see it coming from no less, my lord, than the highest constitutional functionary of the Honorable President. Maybe, my lord, because of state of Punjab, state of Tamil Nadu, state of, my lord, Telangana.
Telangana is not yet either.
That's correct, my lord. But there may have been a doubt that may have arisen in the minds of the Honorable President. The Honorable President now seeks guidance from your lordships as to what is meant by this as soon as possible in Article 200. The exclusion of, my lord, while the question is not framed in that manner, the exclusion of 6 weeks, replacing it with as soon as possible in Article 200, does it have any special portent? Should the governor be mindful of a time frame within which the governor needs to act? Should the Honorable President be mindful if the matter is referred to the Honorable President under Article 201 with regard to what is to be done? Now, my lord, your lordships, as I indicate, my lord, I use the word colloquially, the doors, my lord, are now opened by the Honorable President requesting your lordships to guide the Honorable President and the governors. So what may otherwise have been an inhibitive factor for your lordships to indicate a time frame, your lordships can easily specify if your lordships are able to find from the constitutional scheme, from the constitutional debates, that the intention throughout was that they would act with utmost expedition. If 6 weeks' time was removed in the draft article, in your lordship's understanding of the law and the constitution, if your lordships find, and my lord, this is your lordship's opinion, your lordships are not giving a directive. It is your lordship's opinion that your lordships will be specifying in the advisory jurisdiction. So if your lordship's opinion, collective opinion is going to be that the governor and the president are expected to act with great expedition preferably within a period of 3 months, because 6 weeks was what was contemplated. It becomes only your lordship's opinion. But your lordship's opinion being sought may end up being something that they may be bound to follow in the ordinary course. My lord, so therefore, my lord, my respectful submission at the outset is, this is a much wider jurisdiction your lordships have. They are only asking for your lordship's opinion and advice on what your lordships feel are the, my lord, components and, my lord, the time-related specifications of Article 200 and Article, my lord, 201. My lord, this is my first submission. But if I may just show, my lord, at page 1, my lord, para 1.4, my lord, this very issue that when advisory jurisdiction is conferred on, my lord, the Supreme Court, my lord, Canadian Constitution continues to have it. Australia, my lord, though it's a part of Commonwealth, it has removed these provisions because they felt that this may possibly lead to the Supreme Court encroaching into this legislative or executive spheres. They wanted to keep, my lord, these three completely insular. So, my lord, while the other countries have moved away, US does not have this jurisdiction. My lord, the Indian Constitution consciously chose that they would retain this jurisdiction, my lord, like the Canadian Constitution continues to retain the jurisdiction. It is that retention of jurisdiction, my lord, that was made by the Honorable, by the Constitution that led to the Honorable President now seeking a lordship's opinion. My lord, I have only indicated in para 1.6, my lord, that the Canadian Constitution is the closest parallel. My lord, then I am indicating in para 1.7 that this reference may need to be seen, my lord, from a constructive perspective, not, my lord, an assertive jurisdiction, my lord, that is sought to be exercised. It is not, my lord, confrontational as I see it. It is, my lord, the Honorable President understanding that there is a constitutional power available to the Honorable President to consult your lordships. My lord, they have approached your lordships for seeking consultation. My lord, your lordship's opinion would be any just and correct view that your lordships take of what the constitutional provisions can mean and must mean. My lord, then, my lord, if I may go to the second part of my submission. My lord, this is at page 1322. My lord, just to indicate, my lord, I'm starting with what is the original intent. My lord, now this about the original intent, there cannot be a confusion. The point I'm trying to make is, my lord, that the governor has no discretion. The governor has no options.
No options also.
No options also. All the options are available only for the Council of Ministers to aid and advise the governor. The governor is bound to follow. This is the original intent. I'll show to your lordships. Prior to the Constitution, my lord, 1935 Act resulted, my lord, in 1937 Government of India Act being brought into force. Congress, my lord, won majority in 6 provinces. They had a reservation saying that if section, my lord, the old section 75 of the Government of India Act had a discretion available to the Governor General. My lord, they said we would not want to assume power, though we have majority, because we may not be able to run the governments. My lord, an assurance was given by the Viceroy, and this is, my lord, recorded in Sarkaria Commission report, saying that we will not resort to this power, discretionary power, we will allow you to function fully. So, my lord, prior to the Constitution being made, your lordships notices this history in 1937. 1947, my lord, the moment Indian Independence Act came to be passed, the constitutional provision order of 1947, my lord, immediately made a change saying that in his discretion exercising anywhere, because that old act was continuing till the Constitution was made, in the adoption order, my lord, it was specified that this would not be operative. So by the time the Constituent Assembly was sitting, there was no discretion, my lord, that was available in terms of the Government of India Act because of the adoption order saying that in this discretion will not operate. My lord, I'll just show your lordships that. So when the Constituent Assembly sat down, there was a draft article. My lord, when the draft article was placed before the Constituent Assembly, 2 things happened. My lord, the draft article came to be placed with the, my lord, drafting committee suggesting a recommendation that we must drop this word in his discretion, because that was preceded by, my lord, Shiva Rao's book. I placed it, my lord, I'll just show your lordships. These drafts were initially put out for the public, my lord, asking for views to be given. When views were given, my lord, when the the drafting committee received these comments, such of those comments it found were feasible and were correct, the drafting committee itself, though it proposed the draft constitution by then, it proposed the amendments that need to be carried out. So by the time the matters come before the Constituent Assembly, The recommendation of the drafting committee by then was, in this specific article, Article 175, we may have to delete the word "in his discretion" occurring, my lord, in the first proviso. So, my lord, that, my lord, the Constituent Assembly debates will clearly show to your lordships that throughout, my lord, in the Constituent Assembly debates, the view of all the members was very clear that the governor will not have discretion, the governor will not have options. All the three options are for the benefit, exclusive benefit of only Council of Ministers.
He has to act on the aid and advice of the minister.
That's correct. My lord, also what happened immediately after the constitution, my lord, because this is something where, my lord, if your lordships looks at the arc of history starting from 37, after the constitution, when the president, Honorable Rajendra Prasadji as president was, had a doubt about the Hindu code. He sought the opinion of the Attorney General, he sought the opinion of Sir Alladi. But in Shamsher Singh's case, my lord, just Krishna Swami, Krishna Iyer refers, my lord, to these conversations to say that throughout it was very, very clear the Council of Ministers would be exercising each of the options. The governor would not have any option. But if I may just quickly show that, my lord, from my note at page 1322. My lord, in 2.1, I had mentioned about, my lord, section 75 under the 1935 Act. My lord, 2.2. just indicated for your lordships, my lord, that when Congress party won the majority, my lord, it assumed office only after it received an assurance. At my lord, footnote 2, your lordships will find this is specifically referred to, my lord, in the Sarkaria Commission report, which is also a part of your lordship's order. This history is noted. My lord, then please see, my lord, in para 2.3, Nabam Rabia notices the constitutional, the next stage. My lord, in Nabam Rabia, if I may read with your lordship's permission, my lord, in that extracted part, after independence, there was no intention to permit the governor to exercise any discretion or to take any decision in his individual judgment. This is clear from the India Provisional Constitution Order of 1947 issued in exercise of the powers conferred by Section 9(1)(c) of the Indian Independence Act 1947. Para 3.2 of the India Provisional Constitution Order explicitly deletes the expression "in his discretion," acting in his discretion and exercising his individual judgment wherever they occur in the Government of India Act 1935. Then para 3.1 and 3.2 are extracted. So, my lord, 1947, in the first opportunity, my lord, they said we will have this adoption order, remove this "in this word" in his discretion, because earlier it was dependent only on the Viceroy's assurance. But in law, my lord, that words remain. Now, the moment, my lord, we got independence, they wanted to do away with this discretion to the governor. My lord, then para 2.4, I mentioned, my lord, about the draft article which I have extracted at, my lord, para 2.5. Your lordship sees the proviso under para 2.5. Your lordships will see originally, my lord, this "in his discretion" was a part of the draft article. My lord, then para 2.6, prior to the introduction of the draft constitution in the assembly in October 1948, the draft was widely circulated to the members of the Constituent Assembly for comments. Some members of the Constituent Assembly had suggested that the words which would enable the governor to withhold assent or reserve it for consideration or give assent should be deleted from draft article 175. Notes to the Constitution Drafting Committee specifically mentions this as under. My lord, I've enclosed this B.N. Rao's volume, my lord, for your lordship's consideration. My lord, I'm just self-contained. I've extracted all the relevant parts in this note itself. My lord, article 175, this recommendation, my lord, came from Mr. K. Santanam, Anantaswamy Iyengar, T.T. Krishnamachari, and Srimati G. Durgabai. In Article 175, for the words "declare either that he assents to the bill or that he withholds assent therefrom or that he reserves the bill for the consideration of the President," the words "assent to the bill" be substituted. This was the original suggestion. My lord, the note is by the constitutional advisor, Mr. B.N. Rao. My lord, the note then says, under Article 175, my lord, which is 200 today, the power of the governor to declare, my lord, page 1324. Yes, top of the page, my lord. That note, my lord, is by the constitutional advisor, Mr. Rao.
I had read that. My lord.
Yes. Under Article 175, the power of the governor to declare that he assents to the bill or that he withholds assent therefrom or that he reserves the bill for the consideration of the president, my lords find all three adumbrates are there, will be exercised by him on the advice of his ministers. Accordingly, there will be hardly any occasion to withhold assent from a bill which has been passed by the legislature. There is therefore no harm in retaining the provision with regard to the withholding of assent from a bill in this article. Now, please mark this. There may be cases where it might be necessary for the governor to exercise the power of withholding assent even on the advice of the Council of Ministers. If after a bill is passed by the legislature, the ministers resign before the bill is assented to by the governor, the new ministry which would be formed might not want the bill to be enacted and might advise the governor to withhold assent from the bill. But if the provision relating to the withholding of assent is omitted from this article, it will not be possible for the governor to withhold it. Now, if I may pause. So this is, my lord, to aid the ministry requesting the governor to withhold and send it back. My lord, then if I may read further, there is thus a distinct advantage in retaining the provision relating to the withholding of assent in this article. The provision regarding reservation of a bill for the consideration of the president is also necessary in view of the provisions contained in clause 2 of article 231. My lord, this is 254(2). My lord, in fact, my lord, Mr. Datar had touched upon this. My note elaborates a little more. My lord, the Council of Ministers, when your lordships look at it as a law-making body, if it is making the law, your lordships will start with a good faith doctrine that the legislature, my lord, because your lordships are looking at it as a pure constitutional question. Now, in a pure constitutional space, divorced from facts, your lordships would not presume that a state legislature is not aware of the provisions of the constitution. My lord, when it is making a law, it would know which are the provisions which will require the assent of the president. It would know which are the provisions or which part of an enactment, not the entire enactment. My lord, it can only be sometime only one section, which may require the assent of the
That
president.
is already argued so many times.
My lord, if I may just then read further, my lord. 2.7. At a later part of the same note to the Constitution Drafting Committee, the constitutional advisor, Mr. B.N. Rao, remarked as follows. Accordingly, if the words in his discretion be omitted from the proviso to Article 175, the power of the governor to return the bill to the legislature under the proviso will be exercised by him on the advice of his ministers, and the remarks under Article 91, which is 111, ante will apply to this amendment. Then 2.8. In the Constituent Assembly debate as well, it was clearly noted that there would be no individual discretion available with the governor. The relevant portions of the debate have been extracted. But I have not extracted the entire portions. The learned solicitors has an extensive one. I thought relevant ones to this particular point, I'll place it here.
Tomorrow by 12, your side has to conclude.
I'll take another 20 minutes.
We'll finish.
No,
We were very faithful to time.
the interveners, my lord, I was just laughing.
If they can fit it till 12 o'clock, we'll
Normally, you don't have rejoinders. We all give our views to your lordship, and then your lordships take. We are just assisting. There's no lists here that we have to respond to each other.
That's one.
how come state of Meghalaya is on this side?
Paul Shankaran thinks that there is no voice of dissent here.
Where the governor has, he will act without aid and advice of the council of ministers.
On his own judgment, that's a sui generis.
Yeah, but then you should have been on this side.
The difficulty is the learned, despite our request, we are not getting placed from this side. My learned friend, my lord, is standing to assist the learned AG. But anyway, these are our internal issues, my lord, I can't flag it here. Meghalaya.